So this is something today's session will start with section 148, which is chapter 3 under module 3, module 4. So module 4, chapter 3, and we'll talk about maintenance of public order and tranquility, unlawful assemblies, etc. And this is section 148 to section 151, which is part of chapter 11 of BNSS, which is maintenance of public order and tranquility. And specifically, these are from part A of that particular chapter, which is unlawful assemblies. So let's start with 148. So 148 says dispersal of assembly by use of civil force. So subsection 1 says any executive magistrate or officer in charge of a police station, or in the absence of such officer in charge, any police officer not below the rank of a sub-inspector may command any unlawful assembly or any assembly of 5 or more persons likely to cause a disturbance of the public peace to disperse. And it shall thereupon be the duty of the members of such assembly to disperse accordingly. Subsection 2 says, if upon being so commanded, any such assembly does not disperse, or if without being so commanded, it conducts itself in such a manner as to show a determination not to disperse, any executive magistrate or police officer referred to in subsection 1 may proceed to disperse such assembly by force and may require the assistance of any person not being an officer or member of the armed forces and acting as such for the purpose of dispersing such assembly, and if necessary, arresting and confining the persons who form part of it in order to disperse such assembly, or that they may be punished according to law. Now, this section basically is the first basic section which talks about what is the authority to command a dispersal. So what is the authority to command a dispersal and who can do that? And basically, if it is not dispersing on that command, or before even giving command, it shows a very determined team which will not disperse. In such law and order situation, what are the what is the procedure and what is the conclusion of such a assembly? So part 1 talks about the authority to command the dispersal, who can do it. So basically, any executive magistrate or officer in charge of a police station, or in absence of him, any police officer who is not below the rank of a sub-inspector. So these are the people who are eligible. So any police officer who is up to not below the rank of sub-inspector, we can say, is eligible. So any police officer and any executive magistrate. Now they are basically from the same jurisdiction, they have to be there. Because why the same jurisdiction is normally understood from this is because they will know the local configuration of the crowd, they will know the local issues, and they will know the local problems. So it might be interpreted well with an officer who is from the local location than anybody from any other jurisdiction. So these are the people who are authorized on what kind of assembly? Any assembly of 5 or more people. So any kind of assembly which is of more than 5 people, 5 or more people, which is showing a tendency to cause a disturbance of the public peace. How that will be perceived? That will be perceived by the way they are acting, the way they are behaving, and the kind of actions they've already committed, the kind of communication they're already dispersing. So in this situation, to disperse, the section is around to disperse these people, to scatter them away so that they are not standing together and disturbing the public peace and order. So it is therefore be the duty of such members to disperse. So when these kind of officers are coming back and asking you that you are causing up public peace and order, in that case, if they ask you to disperse, the section 1 says you have to disperse. So this is the authority of the law enforcement officers, the police and the district administrator to act on such kind of situations, while it is also a duty of the people standing there to disperse when a official order is communicated to them verbally also. So it's not that they will come back with a written memo or a written document to come back and ask them to disperse. So it's a verbal order. So once it is done, it is a legal lawful way and the legal way that they have to disperse immediately. Action in the case of non-compliance or in case of seemingly they will not be compliant. So part two is for both of that. So for non-compliance or seemingly not compliant also. So if tomorrow somebody comes back and complains that actions are taken when there was no command given, so then there is a defense also saying that they seemed to be not uh, conducting in a manner that they will not disperse. So they were very well determined, probably by a very intense action. They might already have engaged in some kind of such activities. So in those cases, if the assembly fails to disperse or it behaves in a way that it suggests that they will refuse to disperse, so then the designated officer, I'll just say officer, which includes the executive magistrate and the police officer of the rank, so and so, may take an action to disperse the assembly by force. Then they can use the force. Now, in the basic administrative procedures, the force has to be very optimal. It cannot be something which is beyond the civil force. So it has to be something which is uh, maybe a lathi charge, maybe a warning, maybe just walking into the crowd. So all those things enable them to act decisively to prevent the potential disturbance. So they have to be decisive to go ahead and disperse the crowd. The force could be mental and physical both. But the utilization of a civil force is basically which is allowed. So they can seek assistance from the civilians also. So a civil force they can take from the civilians also who are not members of the armed forces. So they can take the help of the commoners also to help in dispersing the assembly. Probably some prominent people from that area, probably a group of people who are there to safeguard the society along with the police and the administration. So they can take help of such people also in dispersing the assembly, and also they can also allowed to take help of the civil forces for arresting and confining individuals if necessary. Why this is given? Because when these things happen in a spur of a moment or suddenly, which is planned, but it is disclosed suddenly. In those cases, it might be possible that there might not be enough forces along with them. There might be a couple of them, and the crowd might be bigger. In that case, they are allowed to take help from the civil forces. And anyways, there is a nascent responsibility of the citizens also to help the police and the law enforcement when they are requested to for the reasonable reasons. So this provision helps the community involvement in maintaining such public order while ensuring that the police brute force or military force, etc., is not used in a civil matter, because then the consequences will be also echoing after that. The provision also then clarifies that anyone involved in such assembly who refuse to disperse and is apprehended may be punished. And according to law, whatever the law is, the person could be or persons could be punished, and that is to reinforce the legal consequence of ignoring law. So that is something, a consequence of the not ignorance, ignoring the law. When you are on face asked to follow, you have not followed. And if you are clearly instructed, and then in that case, they might be, if necessary, will be arrested and confining those persons into bring it to order, and then punishment will follow. So this is a maintenance of order, very basic first section, which has to be understood very well. It clearly shows the responsibility of both the parties. One party has to, there to be the administration and the police has to be there to enforce the law, and the common citizen has to abide by the law when instructed, because they might go ahead and get into situation which unknowingly or in spur of moment would be something disturbing the public peace. And on receiving such instruction, they should realize and they have to go back. So this is clear responsibility is given, and community engagement is promoted in such section because uh, avoiding any kind of brute force against the people to disperse, because this is just a civil matter and this is not a criminal matter until and unless it doesn't disclose itself over time. Then accordingly the sections would be invoked and the persons would be apprehended accordingly. Now see section 149. Use of armed forces to disperse assembly. Now we come, as I said, every section chapter starts with a basic understanding. That has to be your base understanding. That is the flavor of that particular section. And now everything else is a either procedure or some specific process which is magnified, or some exceptions. Nothing more than that. So section 149 then says, moving further from 148, use of armed forces to disperse assembly. Now, if any assembly referred to in subsection 1, the previous section, cannot otherwise be dispersed. So you use the warning, you use engaging themselves yourself with the crowd, and you also try to use the civil forces. But the it is not being dispersed and you fail to disperse. So it is necessary for the public security. Now, it is a matter of public security that it should be dispersed. Why public security? Because the crowd might go uncontrolled and damage the public property, and private people as well. So that is why the issue of a public security comes, and then it should be dispersed. So the district magistrate or any other executive magistrate authorized by him. So immediately see the wording changes. So the moment we talk about the peaceful dispersal of the crowd using the civil forces, any magistrate is allowed, or any executive magistrate or any police officer up to the rank of civil sub inspector is allowed. The moment it is a more than normal, the moment the consequences become little difficult and tough, the brute force has to be used. Then there has to be some kind of responsibility which has to be inculcated into the process, and that is brought in through the engagement of the district magistrate, who is the senior most executive magistrate in the district, or if he has already designated for such a reason some executive magistrate, so that person. Which means the moment this happens, if it was a district magistrate who was already present there, no problem then. Otherwise, any other magistrate has to consult the district magistrate, take a permission, or take permission from, or engage somebody who was already empowered by the district magistrate to look into those affairs. So who is present may cause it to be dispersed by armed forces. So then by on instructions, it has to be dispersed by the armed forces. Subsection 2 says, such magistrate may require any officer in command of any group of persons belonging to the armed forces to disperse the assembly with the help of the armed forces under his command. So of course, when you engage an armed force, you command that armed force through the officer in charge of that particular command. So whoever is whatever rank, as per the state gadget and as per the procedure manual, or as per the predetermined level of the forces deployed in that particular state. So the responsible officer in command has to be instructed by the direct or indirect officer order from the magistrate. So direct when the magistrate himself, district magistrate himself is there, or the responsible officer is there. Indirect if in case the magistrate is giving an order to the person to take it forward, that magistrate. And to arrest and confine such persons performing part of it as the executive magistrate may direct. So they will direct clearly the officer in charge in command to do. Now, there are provisions which say the armed forces are excluded from any kind of such kind of liabilities, legal liabilities. And why? This is why. Because they just operate as a machinery to reinforce the whatever law and order has to be done, but then they work clearly on the instructions of the people who are responsible to manage that. So they have to be completely briefed upon who has to be arrested and what has to be done, who has to be confined, etc., as the instruction coming through the respective executive magistrate. or it may be necessary to arrest and confine in order to disperse the assembly or to have them punished according to law. So the last word is dangerous when say to have them punished according to law. So in according to law, there are manuals which are drawn, and according to that, they have to punish according to law, which means starting with probably a light beating with the stick or a water cannon, tear gases, and then it can go up to the level of shooting at the lower proximity of the body. Subsection 3 says every such officer of the armed forces shall obey such requisition in such a manner as he thinks fit. So, see very cleverly, the law has also added a small liberty to the armed force officer also, that every such officer of the armed forces shall obey such requisition in such a manner as he thinks fit. So, he also has to apply his mind that what is actually fit. So, if some officer, you know, I'll come back to it. So, but in so doing, he shall use as little force and do as little injury to the person and property as may be consistent with the dispersing the assembly and arresting and detaining such person. So, what is the mind application he has to do? In spite of the heat of the moment, the maybe the officer is afraid, the magistrate is afraid, or whatever has happened, he might sometime overdo, because they are not the people who use the forces, who are on the ground fighting or beating or punishing people. They are the people giving requisition. So then in that case, the person who is specialized to do this is the officer of the armed forces. So that person also has to apply his mind. It's a second level of control which is given to the hand which is operating, that you apply only that much of force which is causing little injury to the people. Because the purpose, what is the purpose? Purpose is not going on a war. Purpose is not going to kill people. Purpose is to citizens who have gone rogue have to be brought to order. So in that case, the assembly which has to be dispersed is the purpose what they have to do it, and then little most injury they have to do. For example, if there are cases where the magistrates have ordered to shoot the people on chest or above the proximity, because they were afraid of seeing those situations which the armed forces are used to. And there have been good examples where officers have done commanded to their forces, because see, the communication between the executive magistrate and the armed force leader will happen. The forces on the ground who are pulling the trigger or running the batons will only take command from such officer. So that is why it is also the responsibility which is inculcated in subsection 3, where they have to also use a mind. They have to apply their mind to put the minimal injuries. So it cannot happen that in a very small crowd of 10, 15, 20 people, and armed forces of 10, 15 people standing there, they are capable to holding them by hand also and taking them if they are not using any firearm. If they're using firearm from other side, then it is, of course, a retaliation can happen to minimize the damage to the police force also. But in that case, they have to use the minimal forces to probably give a small beating with batons, etc., etc., but this cannot be shot in the head. In such situations, subsection 3 will come to the rescue of those people who are affected by such brute force, and the officers will be then answerable on that. So this is an authority to call the armed forces to the district magistrate or any magistrate executive who is empowered by the law, because this is a serious matter, and the operation is also very serious. It is a commanding officer's role to take the instruction from the magistrate and execute it. Then dispersal and arrest is the authority, and the guideline to use the force is minimal. They cannot just go on using the force to kill people unnecessary or injure people unnecessary. Subsection 150. Power of certain armed force officers to disperse assembly. So incrementally more. So when the public security is manifestly endangered by any such assembly and no executive magistrate can be communicated with. So with any commissioned or gazetted officer of the armed forces may disperse such assembly with the help of the armed forces under his command, and may arrest and confine any person forming part of it in order to disperse such assembly, or that they may be punished according to law. But if while he is acting under this section, it becomes practicable for him to communicate with an executive magistrate. He shall do so and shall thenceforward obey the instructions of the magistrate as to whether he shall or shall not continue such action. So, what are the situations this can happen? Say, for example, some election situations in some areas where sensitive areas, or many such areas where some sensitivity is there and the armed forces are deployed. Now, everywhere, every point of time, on immediate reflex basis, a magistrate might not be available. There might be a magistrate who might be communicated, but on immediate basis, it is not available. So then, in those cases, in the such emergency situation, the forces which are deployed, their officers, which officers, who are the commissioned or the gazetted officers of that particular armed forces, they can also start to disperse the cloud. Of course, previous section, subsection 149, subsection 3 is applicable, where they have to be very conscious about putting the minimum damages. But that is just an emergency situation. Immediately after that, they have to immediately contact the executive magistrate and start taking his instruction or her instruction to follow. So this is only to act in a situation of emergency, and then immediately set up the line of command through the executive magistrate. So who are those commanding officers in the armed forces? So in armed forces, these commanding officers could be at the rank of lieutenant, captain, major, etc., who is commanding a particular army. And gazetted officers are the senior police officers who are published, whose names are published such a way in the gazette of that particular state. So either of these level of officers who are responsible officers, and within military or the police forces, mostly military and the paramilitary forces, and who are ranks are listed and recognized by the state gadget, those people are only allowed to take that action, and only temporarily for the emergency situation. So officer in command, then they can use their under supervision such force to what? To disperse such assembly or to arrest such people or to punish also. But then what is the key uh, characteristic of this section is this is just an emergency immediate response which is required to safeguard the public security and the public property. But immediately they have to go back and communicate with the executive magistrate to ensure that the proper chain of command as desired in section 149 is established, and quickly they have revert to the situation of section 149, which is a rapid response capability given in such situations where it has happened and the forces are already deployed. Because the forces are deployed for the reason they might have to act on emergency situation, it balances the civil and the armed forces military roles, and it protects the public order, because armed forces can go up to the extent which could be unbearable to the common people. Section 151, protection against prosecution for acts done under 148, 149, and 150. So, no prosecution against any person for any act purporting to be done under 148, 149, and 150 shall be instituted in any criminal court except with the sanction of the central government, where such person is an officer or member of the armed forces, with the sanction of the state government in any other case. Subsection 2 says no executive magistrate or police officer acting under any of the said section in good faith. In good faith. No person doing any act in good faith in compliance with a requisition under 148 or 149. No officer of the armed forces acting under section 150 in good faith. No member of the armed forces doing any act in obedience to any order which he has bound to obey, shall be deemed to have thereby committed the offense. And subsection 3 says in this section and in the preceding sections of this chapter, the expression armed forces means the army, naval, and air forces operating as land forces, and includes any other armed forces on the unions operating. Officer is in relation to the armed forces means a person commissioned, gazetted, or in part as a officer of the armed force and includes a junior commissioned, a warrant officer, a petty officer also, and a non-gazetted officer from the armed forces. Member in relation to the armed forces means a person in the armed forces other than an officer. So basically, this section then gives a covering effect on all the sections of 140 to 150. What covering effect it gives? That, first of all, let's understand what is done here is in good faith too. It has to be done in good faith by anybody, any of the parties here which are operating in this, the decision makers first. So the executive magistrate or a police officer up to the rank below, not below the rank of a sub inspector who is operating, or a army officer or navy officer or a military officer or a air force officer, whomsoever. So all of these people at the commanding officer level again, then they have a operate in a good faith and on the instructions. So, and the most protected is who? The members of the armed forces who have actually no application of mind apart from pulling the trigger or running the baton. They have no liability at least at all. So the subsection 1 says that all these people, in fact, also the common people who are acting in good faith in compliance with what is instructed. We read about the civil force and the people from civilian background also might be engaged by the district administration for their support in the putting a civil force. So in those cases, the subsection 1 talks about that with the sanction of the central government, when such person is an officer or member of the armed forces, apart from that, there cannot be any action taken upon by them. And when this can happen, this situation also come. For example, there are situations where sometimes the armed forces which are deployed in certain remote areas might go and do something extreme, which is against the humanity, against a lot of many other things. So that is something which is then that has to be acted accordingly with the military or the civil rules, depending upon what the central government takes a decision, what is the procedure, or with the sanction of the state government in any. So I said the paramilitary police forces, etc. also are, for example, state government in those cases. For example, SRPF also comes under this. Subsection 2 says this is now covering, first one was covering the central union forces and the state forces. For example, the commando forces, the CRPF, etc. And B talks about the state forces, for example, state reserve police force, etc. Subsection 2 talks about the executive magistrate, but then they are locked in the place by, there is an accountability created by good faith, because tomorrow if something which is alleged and which was purely motivated by some or other influences by some political parties or some people who are of influential status in the society and they have made him do it, then in that case, this good faith protection will go away and the person is then liable. So if he is not liable, he's not liable until he is doing it in a good faith. And to demonstrate what is a good faith, they have to be very careful about putting the right evidences around that, probably a video recording, probably some news snippets which has come, which will come later, etc., etc. Subsection sub clause B says on subsection 2 that, which is about the people who are acting in on the instruction. C talks about armed forces, where we say they started to act in absence of a magistrate and then they later establish the chain of command. And no member of the armed forces who is doing in obedience an order, which is bound to obey. So the ground forces, they are bound to obey anything, whatever comes. They are not supposed to take a decision, any discretion, or any kind of such kind of planning. So they have to simply obey. So they are also not bound to do anything. They can't be punished because they have done something being obedient and the order which they have to bound to obey. And subsection 3 talks about the expression defining what means what. So these are the conditions of the prosecutions which are given in section 151 and told that in the section that these people can be prosecuted only on the sanction of the central government or the state government, otherwise not. And there is a protection of good faith which is given which says that the people, the executive magistrate, the police officer, the commanding officer, etc., all were working in good faith and they are following the compliance, and the armed forces and the members were also taking the instructions, applying their mind, and obeying whatever order was given, which they are bound to obey. And the definition and clarification of various officers, etc., mentioned here is given. So, this is something which is giving a legal protection to all the officers working in the line of duty and encourage their responsible action, and it gives a very clear clarity on they are not bound to be any wrong until they are following the rules. Now we move to chapter 3, which is public nuisance, section 152 to 163. So this section 152, 163, which we'll read further, 152 to 163 is part of chapter 11, where chapter 152 to 162 is part of chapter 11, which is maintenance of public order and tranquility, is part B. This is public nuisance. And 163 is part of the same chapter, but it is part of part C, which is urgent cases of nuisance or apprehended danger. So let's get into section 152 further. So section 152 talks about the conditional order or for removal of nuisance. So it's a conditional order for removal of the nuisance, which is discussed in this section. So section 1 says, whenever a district magistrate or a subdivisional magistrate or any other executive magistrate, specially empowered in this behalf by the state government, on receiving the report of a police officer or other information, and on taking such evidence, if any, as he thinks fit, consider. So who are the people we're talking about? The district magistrate, who is the ultimate senior most magistrate in the executive ranks. The subdivisional magistrate, who is normally put for the convenience of managing the subdivisions, or any other executive magistrate specially empowered in this behalf by the state government. So for such cases, any such officer who is specially appointed for such role. Morning, mostly these are the officers on special duty. So either of these people, if they receive any report of police officer or other information, for example, some intelligence reports, etc., or some other information from some credible resources also from the administration if it comes, and they have to take such evidence if they think fit. So they have to do some small inquiry, check about couple of things, and bring in the right evidence to take a decision. And then if they consider, number A, that any unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel, which is or may be lawfully used by the public. So if they come to know that any kind of obstruction is being made or nuisance has to be made, has to be removed from a public place only, from any place which is a passage, which is a any way, any river or any channel, any route, which is or may be lawfully used by the public, or that the conduct of any trade or occupation or the keeping of any goods or merchandise is injurious to the health or physical comfort of the community, and that consequence such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed or the keeping thereof regulated. So if any kind of business, any kind of occupation, etc., or keeping of any kind of goods article, merchandise, etc., is something which is again a physical discomfort or a injury to the people and the community, and those have to be removed. So first one was obstruction, second one is any kind of conduct, behavior of trade or any kind of occupation, etc., or some kind of storage of materials, which is again bothering the public in general, the community. Or subsection C, that the construction of any building or the disposal of any substance, as it likely to occasion conflagration or explosion should be prevented or stopped. So in case of any building which is being created, which is uh, or the disposal of any kind of substance. So any kind of biological substance, maybe some kind of chemical substances dumped somewhere, or sometimes some kind of radioactive materials, etc., which is uh, which is dangerous or likely to cause a conflagration. So cause a big fire. So conflagration is nothing but a big fire or explosion. So any such thing which is again dangerous to the community should be prevented or stopped. So we are looking from the community perspective, from A, directly the people creating that, B, their profession or the articles creating storage of articles, C, any kind of construction or disposal of waste which is causing again danger to the community of fire or explosion. Number D, that any building, tent or structure, so permanent or a temporary structure, or any tree is in such a condition that it is likely to fall and thereby cause injury to persons living or carrying on business in the neighborhood or passing by. And that is consequence the removal, repair, or support of such building, tent structure, or the removal support of such trees necessary. So now the things which can fall on people and create problem. Number E, that any tank, well, or excavation adjacent to any such way or public place should be fenced in a manner to prevent danger arising to the public. Now, we talked about buildings falling and etc., structures falling, trees falling. Now, on the ground, if any such hole, any such kind of well, any such kind of tank, any bore well, anything which is there, which has to be covered to prevent public from getting injured or any getting into some danger, or that any dangerous animal should be destroyed, confined, or otherwise disposed of. So, in all these conditions, such magistrate may make a conditional order requiring the person causing such obstruction, nuisance, or carrying on such trade or occupation, or keeping any such goods or merchandise, or owning possession or controlling such building, tent, structure, substance, tank, well, or excavation, or owning or possessing such animal or tree within a time to be fixed in the order to remove such obstruction, etc. So what is the section says now? One, if we see anything which is causing some kind of uh, nuisance to the public. So either by the nature of people obstructing, either by the nature of some kind of trade or occupation, maybe some kind of goods or merchandise, or something falling on the people, something inside which people can fall, etc., or any structure which can fall on top of them, or any dangerous animal somebody is having, or some wild animal coming inside. So, wild animal, who is the owner? Who is supposed to fix that? They have to reach out to that owner. They have to give a notice to the owner. So, if a wild animal comes, the owner is the forest department. So, in all those cases, they have to give a conditional order to remove such obstruction or nuisance. So, in case of first, they will go and instruct the person who is leading that team or the people who are in doing in general, and to remove such obstruction, nuisance. Or even in the case of trade, occupation, or article, they will the people who will be instructed. So number one. Number two, to desist from carrying on or to remove or regulate in a manner as may be directed such trade or occupation, or to remove such goods or merchandise. So things what is causing problem has to be removed, or the business which is causing trouble has to be removed, or to regulate keeping thereof in such manner as may be directed. So they have to put also a regulation as well, that it continues to be in a right state and is in control, to prevent or stop the construction of such building or alter the disposal of such substance. So those things, how has to be done? A process has to be drawn, and that has to be abided by the person who might cause a fire or an explosion if it is not done well. or to stop such construction, to remove, repair, support such building, trees, etc. in case of that, or if fence the such tank, etc., where person might fall, or to destroy, confine, or dispose such dangerous animals. So either it has to be destroyed, or either it has to be confined in some cage, etc., and disposed of probably in a wild area. So all those things has to be uh, in a manner provided in the said order. It has to be written, and if he objects so to do, to appear before himself or some other executive magistrate subordinate to him at any time, and place to fix by order, and show cause in the manner hereinafter provided by the order, should be not made absolute. So in some cases it has to be something where an order has, the person has to be summoned, and a notice has to be given about why the person cannot be show cause, that why this order cannot be absolute. For example, in case of professions which are alleged, or storage of articles which is alleged, and he can also ensure that the person appears in front of him or any other officer, executive magistrate, whom he delegates that. Subsection 2 says no order duly made by a magistrate under this section shall be called in question in any civil court. So this is again a protection for them. And if it is done all in the good faith, etc., and as per the procedure, the in such cases, what is the legal way of approaching it is, the order itself cannot be challenged, but the procedure can be challenged, or under the perception which it was done could be challenged, that the perception it was not right, or the procedure was not taken correctly, it was probably influenced, etc., etc., but the order itself cannot be challenged in any civil court. So a public place includes also property belonging to the state, camping grounds, and grounds left unoccupied for sanitary or recreative purposes. Sanitary means the garbage dumping yards, etc., and the recreative purposes, the gardens, etc. So this section is all about authority to issue orders, and the grounds of actions are given as unlawful obstruction, injurious trades, storages, dangerous constructions, threatening structures, falling or trees, fencing any dangerous areas, and dangerous animals. So all of these, which is creating a nuisance to the public, rather the magistrate can issue a conditional order about what has to be done. The conditions has to be for specific problem, to remove that obstruction, stop and regulate such kind of trade, stop such kind of storage, alter such construction activity, repair or secure threatening structures, and take measures, etc., for safe management of dangerous animals. So that is what is given, and in case where a show cause can be issued and has to be issued, the magistrate can tackle it himself or herself, or maybe delegate it to a subordinate magistrate. The final authority to issue this is the magistrate, and it cannot be charged, it cannot be questioned in any of the civil court. And so there is a prohibition on civil court challenges in such kind of orders. And definition of the public place is given as including anything and everything which is owned by the state as well. Let's move to section 153. Service or notification of order. So such order, when it is happening, there should be a procedure to service also, which is service or notification of order. So the order is practicable, be served on the person against whom it is made in the manner hereinafter provided for service of summons. So wherever the summon, how it has to be given, the same way it has to be given. Subsection 2, if such order cannot be so served, it shall be notified by proclamation published in such manner as the state government may be, by rules direct, and copy thereof shall be stuck up at such place or places as may be fittest for the conveying the information to such person. So this proclamation is not that proclamation what we talked about. Proclamation itself, as I said, that the literal meaning of proclamation is making a formal announcement. So in those proclamations, the context of in the criminal uh, related to the offenders, etc., when we talked about the proclamation, that proclamation about the proclamation of the offender being considered a, a proclaimed offender. This is a proclamation to notify such kind of information. So proclamation word remains common. So proclamation is a word which means literal meaning a announcement. So which is a public announcement. So if this order cannot be served to the person, the way a summon can go. How the summon goes? Summon goes to a person who is definite and his address is known, his place and whereabout is known, and to the limited number of people. In case some kind of proclamation has to be made where a group of person, a lot of people in that category has to be announced, in those cases, then it cannot be served by a summon. How would you serve by summon to unknown name of people, unknown number of people who are getting into such kind of activities which is creating nuisance? In those cases, a proclamation has to be published in a manner so that by rules and they have to direct and copy their or maybe it can be published in prominent places in the city, or maybe it can also be announced on the digital network, etc., so that the people are aware of that. So this is how the service or the notification of the order can happen, either by summon or by proclaiming proclamation publication, either on a newspaper, as a notice, public notice, or probably publishing on a paper and sticking on the prominent places in the city, whichever is fittest way to reach that particular subject of people. If it is something related to Bajar Samiti people and a proclamation in that uh, has to be made, it has to publish in that area. If it is something related to a certain specific group of people, certain specific profession, it has to be announced in the newspaper, etc., or it has to be published in those specific places where it is meant to be seen by those people. So this is a direct service of order or alternative notification, which is part of the section. Now let's move to section 154. Person to whom order is addressed to obey or show cause. So when the such order is going, this order might be already a conditional order which is being given to the person, and person has to obey, or it might be an order which is asking working as a show cause notice. So then in that case, if it is order, you have to abide by, and if it is a show cause, you have to respond. So the person against whom such order is made shall perform within the time and in the manner specified in the order that directed thereby, or appear in accordance with such order and show cause against the same, and such appearance or hearing may be permitted through audio video conferencing. So we've seen earlier also in such kind of cases, if it might be allowed the person to join audio video conferencing, or maybe sometime even represented by an legal practitioner, advocate as well. So the person the very first thing is they have to act if the action is clearly stated in what time, what manner, etc., etc., following all the conditions, or appearance when they are asked to, and show cause if it is asked to accordingly, and the appearance has to be in person, audio, video, or representation. So there is an obligation to comply. The very first thing is an obligation to comply. So in either way, it's an order or it's a show cause, it's a compliance has to be done. So you have to be obedient and up, have that particular compliance done. Then it also gives a chance of show cause, which is nothing but a power given to, and sorry, not power, it's a right given to contest the order also. So that is why the show cause is there, because once an order comes with a show cause, and if you give a show cause is a response, which is a something where you have to contest, appear, and respond and try to put your point also. If it has to be highlighted. And audio video consideration is also given. So encourage a compliance, upholds the due process, and facilitates access to the justice to the people in case the show cause is given as well. So now the condition, if you fail to comply with the section 154, which is either he have not abided by the order or you have not complied by giving a response to the show cause or make your appearance. So if the person against whom an order is made under 154 does not perform such act or appear and show cause, either of the case, he shall be liable to penalty specified in the behalf in section 223 of BNS, and the order shall be made absolute. So in this case, if the person who is supposed to appear has not appeared, or he has not given a show cause, or he has not made himself present in front of the on the date where he was supposed to be present in front of the magistrate, and in that case, if the person does not comes, there are penalties which are given, which are mentioned under Bharatiya Nyaya Sanhita section 223, and that will be applicable on that person, and that is how that procedure has to be followed. So basically, this is a uh, consequence of the non-compliance. We talked about the compliance is mandatory. The consequence of the non-compliance, which is given in this section. The reference to the penalties is given as 223 of the BNS, where the magistrate can take a cognizance and then how they can proceed, and then making an order absolute. So then the order will be made absolute upon non-compliance, and that the order will stand as it was initially issued and removing any ambiguity regarding the individual's obligation and confirming the enforcement of the order without further delay. So the person has to follow immediately. Then encouragement of the compliance is given, clarity in enforcement, and a legal accountability is added at the end. Section 156, where the procedure where existence of public right is denied. So when an order is made under section 152 for the purpose of preventing obstruction, nuisance, etc., in the use of any way, river, channel, place, the magistrate shall, on the appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in respect of the way, river, channel, place, and if he does so, the magistrate shall, before proceeding under section 157, inquire into the matter. So, in the cases where 152, where the person was obstructing a place, a way, a river, etc., etc., in those cases, the magistrate will go back and he will ask that the person who is doing this obstruction on appearance in front of him will be questioned that whether he denies the existence of any public right in respect of the way. So is or river channel place. And if he does so, the magistrate shall, before proceeding. So the magistrate will check if it is something which he believes that he denies the existing of any public right. So if that is something which has to be proved and it is proved, then in that case, the person will be the magistrate will proceed with 157, which is summoning, inquiring, and altering order, etc., etc. So this is something which is an inquiry into the public right, which is checked. So they will inquire that the person against whom basically this order is issued denies the existence of any public right. And this sets the stage for asserting that the claim regarding the public right and the implication of the order. If there is no public right, there is no implication. Subsection 2, if in such inquiry the magistrate finds that there is a reliable evidence in support of such denial, he shall stay the proceedings until the matter of the existence of such right has been decided by the competent court, and he finds that there is no such evidence, he shall proceed as laid down in section 157. So basically, magistrate has to get a reliable evidence in support of. So the person says, no, this is not a public place. This is my personal control. In that case, the proceeding has to stop, and the competent court can come back and make such finding on the evidence and provide a guideline, an instruction with that regard, because the executive magistrate does not have a power to act on the declaration suits. Then subsection 3 says, A person who has, on being questioned by the magistrate under subsection 1, fails to deny the existence of a public right of the nature therein referred to, or who, having made such denial, has failed to adduce reliable evidence in support, shall not in the subsequent proceeding be permitted to make any such denial. So, if the person in the first place is not able to claim that this is not a public right, this is a personal private right, and in that case, in the subsequent proceeding, the person cannot create this denial again. So he has to, it will be then completely presumed that the person cannot claim that right and it is a violation of a private right. So basically, the proceeding has to happen based on the evidence provided on the first instance, and if the person brings in evidence, it has to be proved in a court, competent court, and accordingly then the magistrate will proceed. Or in case if it denies and there is no evidence at all around that, he has no right given again to deny such particular uh, uh, absence of public right. So this is something which brings first of all a clarity on in the proceeding on the legal status. The encourages to use the uh, court process to ensure if there is an evidence which is provided to be validated by the competent court, and then only the magistrate follows. So procedure is very fair, first of all, to ensure that if an magistrate is also giving an order under 152 about obstructing any nuisance, any kind of obstruction, danger to the public, etc., etc., is it something which was based on a valid assumptions by the magistrate or the valid information to the magistrate or not. So there's a possibility of challenging that also is given as part of the fair trial to the person. So he is given opportunity to again respond back. So although there is no power to challenge it in the civil court which is given, but in itself the mechanism is there to validate that, and that is why it is not given. And in that case, if there is a point of legal clarification on the position of the rights comes in, then automatically there is a procedure to refer to the courts to establish the right course of action. And that is why there is no need for a civil action suit also in most of the cases, because there is an inbuilt procedure to validate that also. Now, section 157. Procedure when person against whom order is made under section 150 appears to show cause. So when the person appears to show cause, we were talking about 157 in the 156. Let's see now what is 157. So if the person against whom an order under section 152 is made appears and show cause against the order, the magistrate shall take evidence in the matter as in summons case. So it is done by a summary trial, and in some cases it is summary trial, and there is no particular process so big like we have stages in the normal warrant cases, and uh, various stages of filing the papers, filing the evidence affidavits, examination stages, etc., etc. It all happens in very short form. So the magistrate will take an evidence, which we have seen in section 156. The person is required to give a evidence. Now, if the magistrate is satisfied, which is subclause 156(1)(2), with that order, either as originally made or subject to such modification as he considers necessary, is reasonable and proper. The order shall be made absolute without modification, or as the case may be with such modification. So the magistrate is satisfied that the order, either as originally made or subject to such modification as he considers. So, what is the condition? The person's evidence has failed, and the magistrate is satisfied that the order what he has made originally, he might need to tune it a bit, but then it is reasonable and proper. The order shall be made absolute. This can also happen in a situation where the person is failing to appear also. If the magistrate is not satisfied, so further proceedings shall be taken in the case. So if the order seems to be not right what he has issued earlier, he has to go back and wait for a competent court to come back and respond and act accordingly. So provided that the proceeding under this section shall be completed as soon as possible within a period of 90 days, which may be extended for the reason to record in writing to 180 days. Oh, sorry, 120 days. So there is a time limitation also attached to such kind of things. So it is a response to the order. The procedure is given, how the assessment of the order is done by the magistrate, and termination or of the proceeding in case uh, the magistrate is satisfied that the order was not appropriate and it needs to be um, checked again, or the magistrate has to is considering as subsection 2 it was fine, and he can make it absolute as it is, or through some modification. Some modification means some kind of more conditions or less conditions he can put, depending upon his final understanding while talking to the person or persons. And there is a timeliness of the resolution which is given of 120 days. So 90 days, it can extend max to 120 days. So 3 months to 6 months. Now, section 158, power of magistrate to direct local investigation and examination of an expert. So the magistrate may, for the purpose of an inquiry under section 156 or section 157, direct a local investigation to be made by such person as he thinks fit, or summon and examine an expert. So if there is a provision given so that he can do some local investigation by such persons he thinks fit, so he can bring in additional people to reinforce his understanding, or he can summon and examine an expert also in that area. So, for example, if the person has been uh, given an order where he has put certain structures in a passage area, or he has parked some machinery, etc., in a place where it is considered a passage between two areas. So there is one Mohalla A, one Mohalla B, one area one A, one area B, and there was a connecting link road in between that. And he has obstructed that, and that is the allegation. So he has received an order. Now, when he received an order, he comes back and says, this is not a public property. This link road, which is considered link by people, is actually an extension of my own private road, which is I am using it for my own personal purposes. And these are the documents which in favor of that, I can show that to the magistrate. If the magistrate is satisfied with that document prima facie, he can go back and take an action accordingly. If he has just a word of mouth communication with no presentation of document, he is not satisfied, he will ask a competent court to establish that for him, because it has to be established by only a court. Or in case he wants to make some more investigation and he wants to bring an expert from the property department, or an expert from the uh, legal document reading person who is looking into the document, which is dating from some say 1700 years, so year 1700 upwards, where the language of the document is also not English or Hindi or Marathi, it is in Pali. So in that case, he wants a expert to come and see what is the provision written in the Pali language, or a property expert or an expert advocate who is working in that area. So which is covered in section 158. So this is overall a example which can be drawn for all the sections what we have seen until now. So this is an authority for a local investigation where they can do surrounding people. He can ask some neighbors to come. He can ask some other people who are the prominent old inhabitants of that area to ask the account of the things, or probably some other people who might be have knowledge of that, or he can summon some expert who can come back and help. This is also possible, for example, if there was a structural problem in the building and an order was issued that this is something which is a dangerous building, it might fall on somebody, and the owner comes back and says, no, we have done a structural audit, etc., everything is fine, but the structural audit is also 10-year-old. In that case, the magistrate can summon such a person from the corporation who can come back and examine and give his expert opinion currently for the building, saying, okay, this is the current status of the building. So he can inquire upon also that how old is that particular. He can also check with people that what do you see the building, is it, do you see some things coming down, chipping down, some kind of noise from the building, etc. And then he can ask an expert to come back and check the building also. So those kind of experts can also come, and this is why this is a thorough investigation further which is being done. Even there is a space for an option for given for a expert testimony also, where to take a better informed decision. So it, you see, it can be, it is validated at multiple levels. So there is an opportunity to challenge, and then the best decision has to be obtained if the right processes are followed. Now, section 159, power of magistrate to furnish written instructions, etc. Now, in previous section, where the magistrate directs a local investigation by any person under section 158, the magistrate may furnish such person with such written instruction as may seem necessary for his guidance, and declare by whom the whole or any part of the necessary expenses of the local investigation shall be paid. Normally, it has to be paid by the person who is affected by it. And subsection 2 says the report of such person may be read as evidence in the case. So in the summary trial, this will become we taken as a evidence in that case. And subsection 3 says when the magistrate summons examine an expert, for example, that building structure expert, the magistrate may direct by whom the cost of such summoning and examination shall be paid, which is normally by the person who is affected. In case of the, if we see in the criminal cases also, when the DNA test happens, the cost is taken by the person who is affected or the state, either of the parties. If the state is requesting, state will pay. If the advocate supporting the prosecution from the side of the victim is demanding that, then the victim has to pay. So very same way, the cost has to be paid to such and such person, because there is always a cost together with such kind of investigation by an expert. So this is basically a written instruction for local investigation, which is part 1 of this section, which says any such person who is being called for local investigation, of course, will need to be instructed for a clear guidance without wasting the time of the court and his time. So the person has to be given a written instruction before they come, so that they come back with the right information, they come prepared, and declare by whom the cost, if required, to be paid. For example, the cost to conveyance, how the person is coming, whatever is the cost. So that cost has to be paid that way. In fact, in some of the cases, the witness coming and going cost is also paid by the parties. The report of such person may be read in evidence, so it will be then considered as evidence once it is brought into the court. And in case of expert opinion also, the cost has to be taken care. So procedure or on order being made absolute and consequence of disobedience. Now we're talking about a specific situation where the order is being made absolute. When it was made absolute, one, if the person who is summoned for a show cause is not giving a show cause, not appearing, or in case the magistrate after thorough inquiry believes that everything is fine as he thought and there is no evidence to challenge in the other way. So when an order has been made absolute, in those cases, under section 155, 157, the magistrate shall give notice of the same to the person against whom the order was made. So the notice is given, which is a standard procedure. The person has to be informed about what is happening and shall further require him to perform the act directed by the order within the time to be fixed in the notice. So then you say what has to be done, when has to be done, how it has to be done, and inform him that in case of disobedience, so what are the consequences has to be also added. He shall be liable to the penalty provided by 223 of the BNS, which is how the magistrate takes a cognizance of a problem and the procedure is given in 223. Subsection 2 says, if such act is not performed within time fixed. Now, one is where the notice is given on complying. Number 2 says if it is still not complied, the magistrate may cause it to be performed and may recover the cost of performing it either by sale of the building, goods or other property removed by his order, or by the distress and sale of any other movable property of such person within or without such magistrate's local jurisdiction, And if such other property is without such jurisdiction, the order shall authorize its attachment and sale when endorsed by the magistrate within whose local jurisdiction the property to be attached, and no suit shall lie in respect of anything done in good faith under this action. So let's lead from last to first. Is the last one is talking about good faith. So there is a coverage of good faith given. So everything, whatever is applicable, is always be challengeable from the perspective of good faith. Because if there is something which is done intentionally by some bribe or some kind of influence, there is an absence of good faith. If that could be proved, this whole proceeding will fall. So the subsection 1 talks about a notice of order has to be issued. So when it is made absolute, when it is made absolute, then it has to be operated. So when it is made absolute means now it is confirmed, fixed that it has to happen. There is no other way around. In that case, the full detail of that and the consequences of not doing that is given as a notice to the person, because it's a fair chance given to the other person and transparency to the person, that the person should know what exactly has to be done. He should not be put his mind to uh, decide on how it has to be done and blah blah blah. If it has to be operated, exact instructions should be given, and the person also should be given the reasons of or the consequences what will fall after this also in very clear in clarity. Now in case of uh, the enforcement of the orders can be enforced even if the person is not following. So he can make the action to be performed directly, which empowers the court to ensure compliance with its order. So if the building has to be brought down and the order is absolute in that regard, and the person is not abiding by the rule, and the building has to be brought down, the magistrate will ensure that the building is brought down with the help of the such kind of specially service providers, and the cost of the same has to be recovered by selling the property of this person in this jurisdiction or the other jurisdiction. So the magistrate will make it happen. The cost is recovered accordingly. The property either by removing whatever property the magistrate can sell off. If in case of the magistrate's jurisdiction property, it is fine. If it is not, it has to be endorsed by the magistrate in the other jurisdiction. Mostly it's by the district magistrate in that jurisdiction. We have learned about it earlier. Endorsement and return the endorsed order has to be done, which is the process we have seen. The reason is being it brings an accountability, it brings a checkpoint, and it also brings back the evidence back that it was indeed acknowledged by the particular district officials. And Section 163 says there no suit lies in this particular situation when done in good faith. So no suit can be initiated against this. No legal case, civil case, etc. can be followed because if it is done in good faith, because this is a procedural activity for the sake of law and order, and there cannot be such challenge happening. If it is done in good faith means absolutely for the sake of the public security, etc. So it's a clear procedure for compliance, that how the compliance has to be informed with the consequences and how it has to be enforced if it is not being done. And the legal immunity has been given to the officers in this case for good faith. Now, next point is section 161, injunction pending inquiry. So if a magistrate making an order under 152 considers that immediate measures should be taken to prevent imminent danger or injury of a serious kind to the public, he may issue such an injunction to the person against whom the order was made as is required to obviate or prevent such danger or injury pending the determination of the matter. 2. In default of such person forthwith obeying such injunction, the magistrate may himself use or cause it to be used such means as he thinks fit to obviate such danger or to prevent such injury. And 3, no suit shall lie in respect to anything in good faith by magistrate. This is a good control given by good faith. So this is under coverage of good faith again. And if any immediate measure, for example, let's take again the example of the building. Now this building which is dangerous, which might fall at any point of time, and there is a not very certain information around the structural integrity of that building, and that building is being run for some kind of amusement park. So people are visiting there. So the magistrate can take an immediate measure as an interim order, as an injunction order, saying that we are inquiring, we'll have the process, you will come back, you'll give me a show cause, we'll put an expert opinion, etc., etc. But meanwhile, you stop the operations. So you have to immediately stop using it for the purpose what you're using, the amusement park, and the building has to be vacated to ensure that there is no danger to the life. Meanwhile, when we are discussing and trying if it is checking, validating if it is actually a building which is of that kind of nature. So in that case, injunction order will come and it will immediately stop the access to that building by anybody, and it has to be uh, complied by. If it is not complied by, they can do it forcefully by using the force and put the locks on the building and put some kind of barricade, stickers, etc., to ensure that such injury cannot happen. And if this is done under good faith and not by any other motivation, then there cannot be any suit which can be lying in the any court against this action. Which means if you read otherwise around, as I always say, read the all the laws and all the sections always in the reverse way also if you want to make a good understanding of these sections. So no suit lie in the respect of anything done in good faith, which means a suit can lie if it is not done in a good faith. So it never says that you cannot file any suit. It says it cannot be done if it's done by good faith. If you have a strong reason or evidence, without evidence, you cannot go ahead and proceed in such cases. If a strong evidence, fact, maybe a sting operation, maybe some kind of document, maybe some kind of very clear uh, uh, documents which you have presented to the magistrate, which shows structural integrity as is absolutely fine, certified by so and so organization, received a certificate 5 days back, and then also the order has come, then it is not done in good faith. So all of the places where it says the no suit shall lie in respect of anything done in good faith, read it reverse also, that suits can lie in respect of this if it is not done in good faith. So then it can be challenged that way. So that is why this section talks about the authority to issue injunction for any immediate risk to be mitigated. And if it is not complied by, it can be enforced. And whatever cost for enforcement is can be recovered from the person. And it is a protection against a legal action to the magistrate if it is done in good faith. So the cost is also recovered in this case also by the person. Because if you believe that the police force going to a place and police force doing that vacating that premises, or any such PMC going and vacating that premises and putting a sticker, stamp, seal, etc., it is a cost which is always coming department to department, and that cost is passed to the person who has not abided by. So then that will go there. It's not free. So its immediate protection to the public is something which is taken care of with this section. Empowerment of the magistrate is given in case they see an immediate danger and they have powers to act and enforce that. And then this is something which is brings a insurance of the accountability, which is the if it is done by good faith, it cannot be challenged in any court. So that's about injunction pending inquiry. Because pending inquiry, if something happens, that can be stopped by this procedure. Section 162. Magistrate may prohibit repetition or continuance of public nuisance. We've seen that in the very first section regarding this only, where the action could be done in terms of stopping the activity and also prohibiting a repetition or continuation of such public nuisance also. So we talked about when the businesses and such kind of employment or such kind of things which is causing difficulty to people nuisance. It's not only the one-time stoppage which has to be done, it has to also prohibit such things to happen in future also or continue also. So, for example, kind of nuisance which is happening, for example, Baner, there was a nuisance happening in, as I mentioned, in couple of uh, a building was having about 6 bars in the building. So there were restaurant and bars, and they were not following a regulation of putting a soundproofing, which means all 6 bars till 1 o'clock in the morning or on the weekend until 3 a.m. in the morning were blaring sounds uncontrollable, and the building was surrounded by the residents who are peacefully trying to sleep. So in those cases, it was something where it makes no sense if an order goes to stop it today. It has to be something which has to stop prohibit a repetition and continuous public nuisance also. And in those cases, the city administration has first put a seal on all those shops. Then it has taken an undertaking from the shops, all the bars and restaurants, in the scope of these sections only. And then on the undertaking, they were stopped playing any music. They were stopped operating after 10 o'clock until the judgment had come and findings have come, and until they have put the soundproofing, and they were stopped to sell liquor also until that point of time to control the crowd. But then once they complied by, when the city officers were able to check that, when the relevant fines were paid, then they were allowed to operate again, so that there is no difficulty further to the public. So these are the things which happen. So a district magistrate or a subdivisional magistrate or any executive magistrate or a deputy commissioner of police, DCP, which is the superintendent of police in some places, for example, rural and places where we don't have commissioner and superintendent of police. So state government or the district magistrate in his behalf may order any person not to repeat or continue a public nuisance as defined in the Bharatiya Nyaya Sanhita or any special local law. So either of these people can has an authority to issue an order, that they can issue an order to stop any prohibit any repetition or continuation of the public nuisance in future also. And what does it mean is, if this is not followed, this is an order and this is an absolute order. If it becomes an absolute order, a violation will attract penal actions against them. And the definitions of the public nuisance is given in the Bharatiya Nyaya Sanhita. That is what has to be followed. And nature of the order is, it is a prohibitory or preventive in nature. It's a preventive and prohibitory nature, which is given a order to prohibit anything which is to not to repeat and prevent it to happen in future. So this is a proactive matter, which is proactive measure, which is helping to serve protect the public from the public nuisance, and it helping the in public welfare. So this is a community related benefit which is given by the local administration, and this can be enforced that way. Moving further to the power of to issue order in urgent cases of nuisance or apprehend danger. So this is the one special section which I mentioned at the very start. So power to issue order in urgent cases of nuisance or apprehended danger. So section 1 says, in case where, in the opinion of a district magistrate, a subdivisional magistrate, or any other executive magistrate specially empowered by the state government, like the previous sections, in this behalf, there is a sufficient ground for proceeding under this section, an immediate prevention or speedy remedy is desirable. Such magistrate may be, by a written order stating the material facts of the case and served in the manner provided by section 153, direct any person to abstain from a certain act or to take certain order with respect to certain property in his possession or under his management, if such magistrate considers that such direction is likely to prevent or tends to prevent obstruction, annoyance, or injury to any person lawfully employed, or danger to human life, health, or safety, or a disturbance of the public tranquility, or tranquility is peaceful living, or a riot or an affray. In all these situations, subsection 2 says an order under this section may, in case of emergency or in case where the circumstances do not admit, on the serving of due time of notice upon the person against whom the order is directed, he passed ex parte order. Ex parte is when the other party is not given opportunity to, or has not utilized the opportunity or not given opportunity to defend himself or herself. And when an order is passed, it's called an ex parte order. So subsection 3 says an order under this section may be directed to a particular individual or to persons residing in a particular place or area, or to the public generally when frequenting or visiting the particular place or area. Subsection 4 says no order under this section shall remain in force for more than 2 months from the making thereof, because this is of urgent nature. Anyways, for administration, most of the orders do not stand for more than 1 year, or at the large, most 3 years. Provided that if the state government consider it necessary so to do for preventing danger to human life, health, or safety, or for preventing a riot or any affray, it may by notification direct that an order made by a magistrate under this section shall remain in force for such further period not exceeding 6 months from the date on which the order made by the magistrate would have, but for such order expired as it may specify in the said notification. And subsection 5 and 6 says any magistrate may either on his own motion or on the application of any person aggrieved rescind or alter any order made under this section by himself or any magistrate subordinate to him by his or by his predecessor in the office. And the state government may either on its own motion or on the application of any aggrieved person rescind or alter any order made so. And subsection 7 says where an applicant under subsection 5 is received or 6, so to the application to the magistrate or the state is received, the magistrate or the state government, as the case may be, shall afford to the applicant an early opportunity of appearing before him, or in either in person or by advocate, and show cause against the order. And if the magistrate or the state government, as the case may be, rejects the application wholly or in part, he or she itself shall record in writing the reasons for suing to. So this is something which is taken care in the very urgent matters which has to be done. So this is an urgent situation related order. So in this is empowered to the DM, SDM, and the special magistrate, executive magistrate, who is specially appointed in that direction by the state government. And they have power to give an ex parte order where the order is can stand only for 2 months maximum. And the scope of the order is it has to be to a specific person. It can happen ex parte. A person residing in a particular locality also can be given that such an order, and the public at large in designated areas also can be given such order to not operate that way or not create such kind of nuisance. And this flexibility allow to tailor response based on the circumstances. So based on circumstances, the uh, responses can be given. And the duration is not more than 2 months. On state, if the state government believes that it is very important, it can be made up to 6 months, not beyond that. And the very first section, subsection 1 talk about in case when opinion of a district magistrate. So in that case, the it can be done by their own motion also, by on based on some information, etc., or their own observation also. The power is given. And rescinding or altering that order, the power is given to both the magistrate and the state government, as they both are both the parties who are initiating that. And in case it is on application to either of the magistrate or the state government, in that case, the person is given a quick opportunity to come and represent himself in person or by advocate or whatever means, to come back and present his matter on why the this particular notice or this order has to be modified, or it has to be rescinded completely or partly. So whatever is the reason, the it has to be given with a complete evidences to the magistrate or to the state government. In either the on application receipt of the application, the magistrate or the state government might rescind it fully or partially. Also, they can do it. And whenever they rescind any application fully or partially, of course, they have to ensure that they are putting the reasons in writing, which should show basically that it was done in a good faith and with the right reasons. So, which is immediate action for public safety. It's a balanced approach and clearly gives a review process. Such kind of orders are given very frequently in the administration wherever such situation come. For example, in one of the situations, one convoy of dried fish. It's a old classic case where one convoy of dried fish of about 8 to 10 trucks were parked in a locality by a transport company because he was waiting for some kind of orders from his own logistic company. It started to bring nausea into the people nearby because 6 trucks of dried fish. So then immediately in this situation, the magistrate has given a quick order to immediately vacate that place, and the police will go and get that executed. Or in cases where in Pune there was one criminal who came out of his jail, and then there are about 200 cars which has come to pick him up and take him to his abode. In that case, a quick order was driven, and the immediate nuisance was and the apprehended danger was diffused by asking them to disperse immediately. So many such situations come where even to a public in large also probably has to be given such order. For example, if a public anger is there for some reason for a small pocket of people, organization of people, and they might come back and fuming and they are making some kind of safety risk for the community, such order can be immediately issued that you will not gather and you will not talk about these things which may cause the issue to the public order or risk, etc. So many such examples. Administration keeps doing it day to day basis, especially in the festive seasons, etc., where the blaring of sound, etc., has to be stopped. So all those things keep happening. So where either on apprehending the risk it is done or it is done on the urgent basis. Now let's move to the disputes as to immovable property, which is section 164 to 167. Will continue in the next one, which is part of the chapter 5. So chapter 4 we have completed. We move to chapter 5 now. So procedure 1, where dispute concerning land or water is likely to cause breach of peace. So in this cases where a dispute which is concerning land or water, which is causing some kind of issues. Now, whenever an exec magistrate is satisfied from a report of a police officer or upon information that a dispute likely to cause. So the sources of information could be police, LIB, IB, or maybe the junior state officers, or maybe through an application by people who are concerned about that or who are party to it. So in all these cases, upon other information that a dispute is likely to cause a breach of peace, there might be a breach of peace which can happen concerning any land or water or the boundaries thereof. So these are the basic, most important civil fights which happen where the people fight for the land parcels or fight for the uses of the water bodies or about the claims about various contradicting claims about the boundaries of such lands and rivers, and which is in his local jurisdiction. So, of course, this is a some subject of jurisdiction because any magistrate has to operate in such places where the jurisdiction is operative in such cases because he owns the management of the properties in his jurisdiction only. So he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by an advocate on specified date and time. So the summons are issued so that the person can, or represented by an advocate, or by himself, or only by advocate. Either way, the person has to attend and to put in written statement of their respective claims as respect to the fact of actual possession of the subject of dispute. So, as in any court, they have to come back with a written statement on that date. Now, if you see, this is something which is operating as a summary trial because the executive magistrates always work on the summary trials. They cannot work on the warrant-based trial kind of situation. So they have to minimize the overall process of the judgment, and that is why instead of calling off a specific stage of evidence, interim relief, crosses, etc., it is a shorter way of doing it. Then when they came, both the parties come back with their own written statement on the very first instance. Subsection 2 says, for the purpose of this section, the land or water includes building, markets, fisheries, crops, or other produce of land, and the rents or profits of any such property. So this is all so included in the expression land or water. So it does not only includes literally the piece of land which is barren or having no building, etc., or a water which is purely only a water flowing in some source or stored in some source. It does includes a building, a market, a fishery, or some kind of crop, or other products of the land, or rents or other profits of such property. So this dispute is anything in the water also and on the land also. So that is also scope of the land and water. Subsection 3 says a copy of the order shall be served in the manner provided by this Sanghita for the service of summon upon such persons. What is the way the summons are provided? It has to be directed to some specific people on some address with why, what is the reason, and what is the expectation, and what is the time, etc. And the method of appearing, where and how, etc. is also given, as the magistrate may direct, and at least one copy shall be published by being affixed to some conspicuous place at or near the subject of dispute. So near the dispute area also, because if the place is of dispute, what is the basic of putting something written on a wall or a conspicuous place? The people will able to see, and definitely everybody looks into the place of dispute. They must be definitely putting their eyes, if not anywhere else, they must be putting that. So that is why it's make quite logical to put that in a conspicuous place at the near the subject of dispute also. So if it is, you can put on a board on the those places. So the magistrate shall, subsection 4 says, without reference to the merits or the claims of any of the parties to the right to possess the subject of dispute, pursue the statement so put in, hear the parties, receive all such evidences as may be produced by them, take such further evidence, if any, as he thinks necessary, and if possible, decide where any and which of the parties was at the date of the order made by him under subsection 1 in possession of the subject of dispute. So, of course, when we're talking about the dispute of land and the water, definitely if there is a dispute going on, definitely there is a one party who might be in the position. So the magistrate will, without reference to the merit. So as this is a trial, it's a summary trial kind of thing. So in that case, nobody can talk about the merits of the claim of the parties at this point of time. So without any reference to that, the or to the subject of dispute, the very first thing what he has to do is to verify the claims, to understand what is the locus standi and what is the legal position of those people. And for that, they have to submit the statements. The statements has to be recorded while hearing to the parties and receive all the evidence from them. And if the magistrate wants, he needs for more clarification, some more evidences which are missed and which are additionally required, he can ask those to be presented, and which the parties was at the date of the order made by him under subsection 1. So that those things have to be presented. Provided that if it appears to the magistrate that any party has been forcibly and wrongfully dispossessed within 2 months next before the date on which the report of a police officer or other information was received by the magistrate, or after that date and before the date of his order under subsection 1, he may treat the party so disposed as if the party has been in possession of the date of his order under subsection 1. So if it is appears to the magistrate that any party, one of the parties of course will have the position, so has been forcibly and wrongfully dispossessed. So that party was forcibly thrown out of that premises, has been thrown out, made vacate that particular premises within 2 months, next before the date on which the report of a police officer has received. Within the 2 months of time, when the report from the police officer or other information which he has received to initiate the matter, or after the date and before the date of his order under subsection 1. So when he has issued some order to the parties to bring in the evidences, etc., he may treat the party so dispossessed as the party being in possession. So he gives the benefit to the party who has been forcefully evacuated from that particular property. Subsection 5 says, nothing in this section shall preclude any party so required to attend or any other person interested from showing that no such dispute as aforesaid exists or has existed, and in such cases the magistrate shall cancel his said order and all further proceeding thereon shall be stayed, but subject to such cancellation, the order of the magistrate under subsection 1 shall be final. So nothing in this section will stop any party to require to attend or any other person who can come back and say that no such dispute is there. and never it has existed. So if the magistrate is satisfied, he can cancel his order and all further proceeding, because then it is not necessary, and any proceeding which is there has to be stayed, has to be stopped, frozen in the time. Subject to such cancellation, the order of the magistrate under subsection 1 shall be final, where he has asked for the people to explain the dispute. Subsection 6, subclause A says, if the magistrate decides that one of the parties was or should, under the provision of section 4, be treated as being as a petition, where who was forcibly thrown out of the said subject of dispute, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law. So the magistrate can also temporarily settle that person who he has a solid information of being thrown out by criminal force, who a person is being thrown out of the position has been snatched by the other party. In that case, the magistrate can issue an order declaring that that party is entitled to possession. So he can settle that party who was evicted forcefully into that particular place as the into the position of a lawful position, but then until when the due course of law happens, because the final decision will always come from any competent court and forbidding all disturbance. So he can also give a security to the person through the instruction that nobody will disturb such position until such eviction happens, if at all, through some kind of legal competent court order. And when the he proceeds under the provision of subsection 4, may restore to possession the party forcibly and wrongfully disposes. So then this is how Section 4 is enacted. Subsection 6, subclause B says the order made under this subsection shall be served and published in the manner laid down in subsection 3. So very same way, the order has to be put into the disputed area also, where the first party who was forcibly thrown out has to be uh, settled back into the position. Subsection 7 says when a party to any such proceeding dies, the magistrate may cause the legal representative of the deceased party to be made a party to the proceeding and shall thereupon continue the inquiry. So there should be somebody from the legal representative who should be part of it. And if any question arises as to who the legal representative of the deceased party or the purposes of such proceeding, all person claiming to be representative of the deceased party shall be made parties thereto. So at the moment, anybody or everybody who is the legal representative of deceased party for the purpose of proceeding, all persons who will claim will be considered the party. If the magistrate is of the opinion that any crop or other produce of the property the subject of dispute in a proceeding under this section pending before him is subject to speedy and natural decay, he may make an order for the proper custody or sale of such property, and upon the completion of the inquiry shall make such order for the disposal of such property or the sale proceed thereof as he thinks fit. So this section subclause is about the preserving the value of the things which could be destroyed over time and which has to be sold, so or preserved somewhere. So in case it can be preserved, it can be preserved. If it needs to be sold, it needs to be sold, because the things could be biological and it might decay. So in that case, the sales proceed, whatever money has come from the sale or the sale, the thing itself, the produce itself, if it is stored and possible to store, that will be given back to the person who is the rightful owner, later decided. Subsection 9 says the magistrate may, if he thinks fit, at any stage of proceeding under this section on this application of either party, issue a summon to any witness directing him to attend or to produce any document or thing. So the magistrate can also ask such person. For example, somebody who is claimed to be part of the witness who has seen the person giving the right or patta, etc., to the person who is now claiming the position, or any such witness. Nothing in this section shall be deemed to be an derogation of power of magistrate to proceed under section 126. So this is something which is a section which talks about the procedure when dispute concerning land and water is going to cause breach. And there is one very interesting section subpart where it takes all the parties who call themselves legal heirs or legal representative, all of them will be made party. So what is the legal position in that? Because this is not always guaranteed that whoever is presenting himself or herself as a legal representative are actual legal representative. But please understand, this is for the purpose of running this particular procedure, the decision wherever it has to be seen for establishing some kind of position, establishing some kind of declaring some kind of position, or declaring some kind of representative legal hireship, etc., is a subject matter of a court. This cannot be done by a magistrate, and that is why it is just the two group of parties which the magistrate makes and works on it. Later, a point of time when the execution comes, that point of time, the competent court will then decide who all are really the legal hire and on whom this will be applicable. So this section is basically from the magistrate perspective, and it cannot touch the competent court's jurisdiction. That is why he can just work with the group at the moment, because his primary purpose to clear the dispute. So it's a commencement of the proceeding which is given in case of such situation, which is mentioned here. The definition of land and water is on land everything, in water everything. And service of the notice is the very first thing which has to be done to the parties, and the examination of evidence without any uh, thing about the merit of the case has to be done. If any additional evidences, additional witnesses are required, those also could be summoned. An opportunity to contest the order is also given to the people. Magistrate's decision on the position is taken depending upon if he believes somebody was dispossession forcefully, he can give that person a position. If see, this is also the same case where he has given a position, but the eviction can also happen if the court decides so. Procedure at the basically continuation after death is the all the legal hires who claim to be are put into one packet and they all become one party, and any perishable property is taken care either by proper storage or by sale, and the proceeds of the sale or the gift, the thing itself is given back to that particular person, of course by deducting the cost. And then summoning of any witness can also happen on request at later also, and any non-derogation of other power is given, which is 164.10, that the provision of this section does not limit the or undermine the power of the magistrate. It is something magistrate's authority in dealing with the public nuisance, etc., remains the same. It is not covered by this section. Now, moving to section 165. Power to attach subject of dispute and to appoint a receiver. Now, you see the word, the moment the word receiver comes, the word executive is vanishing. So if the magistrate at any time after making the order, so it is now given to the competent court also. The moment you see the only magistrate written, it is both the magistrates in some cases, and only court magistrate, judicial magistrate in some cases. So subsection 1 says if the magistrate at any time after making the order under subsection 1 of section 164 considers the case to be an of emergency, or if he decides that none of the parties was then in such position as is referred to section 164, or he is unable to satisfy himself as to which of them was then in the position of the subject of dispute. So he may attach the subject of dispute until a competent court has determined the rights of the parties thereto with regard to person entitled to possession thereof. So magistrate has a limited power, executive magistrate. So this magistrate cannot go ahead and decide on such kind of disputes if it is not prima facie looking to him. He can sit across and he can look into things which are prima facie, the validation of the document, witness, etc. But if it has to be decided by a competent court, if the situation is of that scenario, then if he can is not able to make a decision also which party has actually the possession, and is not able to satisfy himself in such position of the such subject, then to who was in the actually position of the subject of dispute, then he may attach the subject of dispute until a competent. So he can attach that particular property at that point of time, provided that such magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of peace with regard to the subject of dispute. So his attachment and the court's attachment is little different. So his attachment is taking in custody only up to the point of time when there is a breach of trust, breach of public tranquility, etc., is not happening. If he believes it is all fine, let the he can withdraw the attachment. So how the attachment will happen of the land or water? He can do fencing. He can put a notice there, uh, and but if he believes that there is no breach of peace, etc., he can let go. He can withdraw that attachment also. So his attachment is different. While we have seen in the court attachment, what happens it is then sent to the is normally for the purpose of selling it, disposing it. Subsection 2 says when a magistrate attaches the subject of dispute, he may, if no receiver in relation to subject of dispute has been appointed by the civil court. So civil court will appoint a receiver normally, make such arrangements as he considers proper for looking after the property, or if he thinks fit, appoints a receiver thereof who shall have subject to the control of the magistrate or the power of receiver in CPC. So CPC power of receiver is considered in CRPC, which is BNSS now, and it is has the same definition, powers and appointment procedure. So that is the same. So magistrate either when he attaches the property of dispute, he may, if no receiver is received, he can himself make an arrangement so that the property is taken care. Or if he thinks fit, appoint a receiver according to the CPC. So ultimately, either the court or either him, according to CPC procedure, they have to appoint a receiver who has to look after the property, who receives the property on behalf of the law and takes care of the property. Of course, the costs are taken care by the parties. So, provided that in the event of a receiver being subsequently appointed in relation to the subject of dispute by any civil court, the magistrate shall order the receiver appointed by him to hand over the possession of the subject of dispute to the receiver appointed by the civil court, because courts have a higher authority. And once if the he has appointed a receiver, and later point of time the civil court also comes ahead and talks about is also appointing a receiver, in that case the receiver appointed by him has to hand over and move out. So he will discharge the receiver appointed by him and may make such other incidental or consequential order as may be just. So whatever etc. is required, he will do. So nutshell, this section is about condition for attachment. In the previous section, we have seen the magistrate can give a temporary possession to the person until the court comes back with a competent court comes back with a decision in that regard. But in case he has no idea, he is uh, not able to satisfy himself about who has to have the temporary possession also, and the case is emergency or some kind of matter which is has to be decided by the court now. So then in that case, the magistrate can take the possession of the property, he can attach the property, and he has to withdraw the property when he sees there is no point of people fighting on that piece of land or water. So that is something which has to be done. Then second part talks about the receiver appointment, where once the property is attached, he has to appoint a, if civil court has not done any appointment of a receiver and it is required to take care of the property, some kind of receiver is required, then in that case he will appoint a receiver as per the CPC procedures. But in case later point of time, if the court appoints, then he has to withdraw his receiver, discharge him, or any other such order he can make depending upon the situation. So this has to a transition should happen from the his appointed receiver to the civil court appointed. So it prevents the primary purpose why this section started is for prevent any escalation of the issue. So the attachment itself is from the magistrate is done by to stop any escalation of the issue. And then effective property management is effected through receiver by court or the magistrate. And in case once the final authority, which is court, which comes, then he has to discharge his receiver and the court has to take over in the situation. Now, section 166, dispute concerning right of use of land or water. So, where it is sorry, a right of use of land or water. So, whenever an executive magistrate is satisfied from the report of a police officer or upon the information that a dispute likely to cause a breach of the peace existing regarding any alleged right of use of any land or water within his local jurisdiction. So key ingredients remain the same. So he is informed by police officer or by some source and for something which is in his own jurisdiction. Whether such right be claimed as an easement or otherwise. So under easement, which is something which is giving a person to use those things as per his enjoyment of that particular property. So whether the such right be claimed as an easement or otherwise, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by advocate on a specified date and time and put in written statement for the respective claims. Now, this is only for the purpose of uses. That was of purpose of ownership, previous one. So, if it's only for purpose of uses. So, for the purpose of this section, expression land and water has the meaning given in 164. So, everything, whatever is there from that perspective, but uses. Subsection 2 says, the magistrate shall pursue the statement so put in. Here the parties receive all such evidences as may be produced by them, respectively consider the effect of such evidences, take such further evidence, if any. So all everything, whatever is followed in section 164, the very same way, he will get the evidences, hear the parties, read the written statements, ask for additional evidences, witnesses, etc., and decide whether such right exists, if the right exists of either of the parties or both the parties or not. And the provision of section 164 shall, far as may be, apply in such case of such inquiry. Subsection 3 says, if it appears to such magistrate that such right exists, he may make an order prohibiting any interference with the exercise of such right, including in a proper case, an order for the removal of any obstruction in the exercise of any such right. Provided that no such order shall be made where the right is exercisable at all times of the year, unless such right has been exercised within 3 months next before the receipt under subsection 1 of the report of a police officer or other information leading to the institution of the inquiry, where the right is exercisable only at particular seasons or on particular occasions, unless the right has been exercised during the last of such season or on the last of such occasion before such receipt. So, no such order shall be made where the right is exercisable at all times of the year, unless such right has been exercised within 3 months next before the receipt. So before it received, within the next 3 months, it has been exercised on the report when it was received by the police officer, like the previous section, or where the right is exercisable only at the particular season on a particular occasion only, and unless the right has been exercised during the last of such season or on the last of such occasion before such receipt. Subsection 4 says, when in a proceedings commenced under subsection 1 or 164, the magistrate finds that dispute is regards an alleged right of user of land water, he may, after recording his reasons, continue with the proceeding as if they had been commenced under subsection 1, and where when any proceeding commenced under subsection 1, the magistrate finds that the dispute should be dealt with under section 164, he may, after recording reasons, continue with the proceeding as if they have been commenced under the subsection 1. So, the proceeding commenced and subsection 164 magistrate finds the dispute regarding right of the user of land and water, then it becomes 164, because it's not again about the right of the users of that particular land or water. It becomes the right of the user of the land and water. So it is something which is about initiation of proceedings in case of such dispute about right of use of land or water. When it comes, it allows the exec magistrate to initiate any inquiry, where, as he does in 164, he can ask the person to publish their written statements, etc., and a written order in that context has to be given to the parties who are connected in the dispute. The evidence gathering has to be done. An order on determining the right has to be then done. So if the magistrate the magistrate definitely has an authority to issue order prohibiting interference with established right. Or if the magistrate determines that a party has a legitimate right of use, they can also order the removal of obstruction. However, certain conditions are imposed here. What conditions are imposed? If the asserted right can be exercised year round, it must have been exercised within the 3 months preceding to the inquiry initiation. So before the 3 months, it must have been exercised when the complaint has come, inquiry has started. And if the right is seasonal or occasional, proof of the exercise during that last applicable season is necessary. So that's why it will give a flavor of a right or even easement also. For example, in case there is a party whose land is landlocked, and then there is a possible no possibility of he coming out of the place, but there is a common road which goes via the one of the parties which has been used year long. So then that is something where it is used year long. Or similarly, some seasonal exercise of some orchards, some fruit cutting, etc., is happening at that point of time. It can only be done from passing through some other uh, uh, land parcel to come to that land parcel, because in that season the river is swelled and filled with water in the other two sides of the land. So it has been used occasionally on that season every year because of that kind of seasonal tropical changes of that particular land. So that is something which is required to be shown and exercised. So if the year long the person has to go out of the land, that case within 3 months he has exercised that right of going out of the land because he is going every day out. So that is operation acceptable. Or seasonal thing, the example which I gave. So under section 166(4), if a dispute which is regarding land and water right arises in proceeding initiated under 164. So if the same dispute regarding the land or water right, which is arise in the proceeding in 164, the magistrate can continue those proceedings as if they were instituted under section 166. So if the already there is a subject about 164 which is running for the same land and water dispute, in that case, the 166 will also be merged into 164. And recording the reason for this decision, the this foster an efficient and coherence in handling the related legal matter. So if right to use of land water is also something which is challenged, apart from the right of that particular land or ownership of the water body, in that case, the cases has to be clubbed and it has to be run under section 164. 166 can be the merged with the 164 proceeding. So this is a proactive legal framework which is given under 166, and it's something which encourages a evidence-based submission, which is part of 164 also, and it is something which is established to ensure the rights of the user or the easement rights, etc., are ascertained and taken care, and it brings in a very timely resolution of the dispute, minimizing the any potential issues, and with the possibility of clubbing it, it becomes far more faster also, and it a very clear procedure given for the claims, how the procedure has to be done to make such kind of inquiries. Now, local inquiry we have been talking. So, section 167 talks about the local inquiry. So, whenever a local inquiry is necessary for the purpose of 164, 165, or 166, in either of the cases, the DM or the SDM may depute any magistrate subordinate to him to make the inquiry, and may furnish him with such written instructions as may seem necessary for his guidance, and may declare by whom the whole or any part of the necessary expenses of the injury shall be paid. And the report of the person so deputed may be read as the evidence in the case in the summary trial. And when the any cost has been incurred by any party to a proceeding under section 164, 65, 66, the magistrate passing a decision may direct by whom such cost shall be paid, whether by such party or by any other party to the proceeding, and whether in whole or in part or proportion, and such cost may be included any expense incurred in the respect of witness, advocate fee, court fee, etc. So local inquiry has to be done by a magistrate which is appointed by the DM or the SDM, and he can bring in furnish a report, and he has to be given a written instruction for this guidance before when he conducts the inquiry, and whatever the report comes back from this particular person is considered as a evidence. So basically, uh, any authority to conduct an inquiry which is given. So it allows a DM or SDM to appoint a magistrate, and for allowing him for efficiency, they have to give an instructions which is in written, and which is also something which brings a consistency also on the understanding. So written instruction has to be given. Expense responsibility, which is a magistrate has, which is appointed, has a designated, has an authority to designate who will bear the cost associated with the inquiry, and this will include full or partial coverage of the expenses, and it clarifies financial responsibilities among the parties involved, which can help mitigate dispute over cost later on. So they will have to, magistrate will decide who will pay, and the whatever report he presents has an evidentiary value. The allocation of cost is also, in all those cases, is done by the magistrate. The magistrate can determine whether the cost should be paid by party who incurred them or by another party involved in the dispute. Or cost may include expenses related to witness, etc., advocate fees, etc., etc. So, in case if both the parties have come back to the magistrate and they have come back and uh, brought this subject for a mitigation, in that case, both the parties will pay. In case one party was in a peaceful enjoyment of the right and the other party has done an adverse position and tried, have thrown them out, and if that comes out as a conclusion, then the party who has done this will have to pay that particular thing, or either configuration, whatever is deemed right at that point of time. So efficient inquiry process is something which is very uh, much clear and brought forward by this section. It gives a guidance and clarity about the written instruction, the cost, etc., and the evidentiary value and financial responsibilities, which is ascertained in this particular section. Now we move to maintenance of wives, children, and parents, which is chapter 6 of this module, and order of maintenance, which is section 144 to 145. So this order of maintenance of wives and children and parent, which is chapter 6, is actually chapter 10 of the BNSS, which is the order of maintenance of wives, children, and parents. It has got some more sections which will be part of the next to next chapter. So section 144 talks about order of maintenance of wives, children, and parents. Now, as we know, the maintenance can be recovered from multiple different avenues of the law. This is one of them. For parents also, there are certain laws about the senior citizens. The children also, there are certain laws relating to the juvenile. And for wives under, if it's a Hindu or it's a Muslim, under relevant religious acts also, this is possible. Or even under certain domestic violence laws also, it is possible. But now we specifically talk here in the one provision given under BNSS. So section 144 is about order of maintenance of wives, children, and parent. The subsection 1 says if a person having sufficient means neglect or refuses to maintain. So these are all the words which are very important in case of such a litigation, such a matter comes into the court. Now, section 144 is a nature of a civil and criminal both. It has got a dual property. From the perspective of recovering cost and money, it is civil, and from the perspective of litigation, which is allegation, it is also criminal in nature. So it has a hybrid nature. In spite of being part of a CRPC or BNSS, it has got a hybrid behavior. So if a person having sufficient mean, so that person has a sufficient mean that has to be proved, neglects or refuses, negligence is also there, or refusal is also has to be proved, and to maintain whom? A, his wife, who is unable to maintain herself, very clearly. Number B, his legitimate or illegitimate child, whether married or not, unable to maintain itself. So the children, either way, legitimate, illegitimate does not matter, but married or unmarried also does not matter. What matters is they are able to maintain themselves or not. His legitimate or illegitimate child not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury unable to retain itself. So either of the child, legitimate, illegitimate, who is not a married daughter, because then she is been taken care, who has attended majority. So these people who have attended majority also. So this child is covered under section B previously, now covered under this particular subclause when the child has also attained majority, when this child is by any physical or mental abnormality or injury is not able to maintain. So B, C is extension to B for such special situations. Then subclause D says his father or mother unable to maintain himself or herself. So who are included? Wife, children, father and mother. So a magistrate of the first class, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother at such monthly rate as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. So this magistrate can, upon proof of such neglect, if it happens, refuse or refusal, order such person to make a monthly allowance to these people. And on certain monthly rate, what the magistrate will decide after hearing the parties, and such magistrate, if thinks fit, and then pay the same thing as the magistrate will instruct. Either you pay directly to the bank accounts, or you pay by the cash and get a receipt, or you pay to the court registry, and which is then deposited in the bank account by the court registry to the person who is looking for that maintenance. Provided that the magistrate may order the father of a female child referred to in subclause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such female child, if married, is not possessed of sufficient means. So if you see subclause C, it is excluding the married female child, but the magistrate can still order for the father of a female child who is mentioned in clause B and excluded in subclause C to make such allowance to some allowance until she attains her majority, if the magistrate is satisfied that the husband of such female child, if married, is not possessed of sufficient means. The husband has no money because she has not attained her majority. Now, this is something which is related to a situation where the girl is minor and married. This is seldom possible nowadays. So it was something which is brought from the past, where these things were legal and allowed also, but it is still allowed in certain tribals and certain areas where it is still allowed. So that's why it does have a significance in those areas. For example, Tamil Nadu tribes, they have a legal age of marriage of 14 years also in some places, because it's a continuation of their culture. Provided further that the magistrate may, during the pendency of the proceeding regarding monthly allowance for the maintenance under this subsection, order such person to make a monthly allowance for the interim maintenance of his wife or such child, father or mother, and the expense of such proceeding which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time declare it. So the pendency of this particular proceedings takes time. Normally it takes at least a year or two. So in that duration, when the magistrate may also proceed regarding a monthly allowance for the maintenance under this subsection, and order this person to by the time pay a monthly allowance as an interim maintenance for his wife or the child or father or mother. So this expense has to be paid until a final uh, judgment comes around that particular amount, which has to be fixed as a monthly payment. So that is something which is given under this particular clause provision. And this provision also says, provided also that an application for the monthly allowance for the interim maintenance and expense of proceedings under the second proviso shall, as far as possible, be disposed of within 60 days from the date of the service of notice of the application to such party. So when a case is filed under this section, what happens is the other party, the husband, is sent a notice, and it is referring to the same notice saying the persons have to also this particular interim maintenance has to be resolved within 60 days from the date of service of notice to the application of such person. So that is something which has to be done, but practically it doesn't happen that way mostly because the application takes some time. Then most of the time the documents are not served well by the other party. Then most of the time the documents are incompletely served to the other parties. Then the asset and liability, etc. documents are forgotten. Then that has to be brought in. And then the hearing for the interim application, because to seek an interim benefit, the party who is affected has to also file one interim application along with the main application. So that is also has to be heard. So proper date, time, hearing has to be ascertained for that also. So explanation: for the purpose of this chapter, wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. So even if in this for this section, the wife means who is already a divorced wife also, but she has not remarried. So that is where the the woman continues to have a title of wife under this section even if she's divorced and has not married. But then please understand, this is also looking back to subsection 1A, the wife unable to maintain herself. So she should not have married and she shouldn't have any way to support herself also. Subsection 2 says any such allowance for the maintenance or interim maintenance and expenses of proceedings shall be payable from the date of the order, or if so order from the date of the application for maintenance or interim maintenance and expenses of proceeding, as the case may be. So the extent from time from which it is applicable is purely discretion of the court, and but there are a lot of Supreme Court judgments around that where it is advised to pay from the date of application in the court. And the legal logic behind that is the person was impacted not from the day when the order has been given. The person was impacted when he brought the cause to the court. Subsection 3 says if any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines. So then it will be considered a fine, and such a warrant would be issued, and may sentence such person for the whole or any part of each month's and may sentence such person for the whole or any part of each month's allowance for the maintenance or the interim maintenance and expense of proceedings, as the case may be, remaining unpaid after the execution of the warrant, to imprison for into imprisonment for a term which may extend to 1 month or until payment if sooner made. So this is a difficult clause which talks about imprisoning the person for any non-compliance of such orders by the court and for the whole or the part of the payment which is pending from this person, the husband, provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. So within a year, limitation period is given. Until an application is not made, the recovery of such amount, for recovery of such amount, no warrant will be issued, which is a distress warrant application. So this is called a distress warrant. So provided further that if such person offers to maintain his wife on conditions of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer if he is satisfied that there is a just ground for so doing. So if such person is offering now, when this matter is instituted against him in the court, that I will maintain the wife on condition of her living with him. So I'll pay her the things if I'll completely maintain her if she comes back and stays with me. But she refuses to live with him. Then she says, no, I don't want to take this condition. Such magistrate may consider any ground of refusal stated by her and may make an order under this section, notwithstanding such offer, if he is satisfied that there is just ground for so doing. So then he can make an order in this section, notwithstanding such offer. And if a husband has contracted marriage with other women or keeps a mistress, it shall be considered to be just ground for his wife refusal to live with him. Subsection 4 says no wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and expenses of proceeding from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. In all these cases, she cannot be paid a maintenance. So, in a lot of cases, we have uh, personally we have attended, we have seen a lot of situations where there had been a clear case of adultery, and there are proofs around that. There are pictures, images, videos, hotel receipts, etc., which is showing the clear cut situation of adultery. In those cases, the courts will not go ahead and pay let any the lady any kind of maintenance because she's living in adultery. There are sufficient reasons she refused to live with her husband. We have seen matters where wives have sent uh, contracts to the husband saying, "You stay out of this house, you stay separately, and I uh, want to stay separately too, and then you maintain me." So that is something where she is willfully deserting her husband. She is not she is refusing to live with the husband, or if they are living separately by mutual consent, or if such kind of agreement is already executed on behest of the wife has given, and she is made the husband sign an agreement, which is also happens, and he both are staying separately. So, in all those cases where this happens, the lady herself has created a situation where, in case of adultery, a husband might refuse and will definitely refuse to entertain any support to the wife. Or in case of any sufficient reason, she refuses to live with her husband, or she goes away to her maternal house and is not showing any point of return, or they are living separately by signing a contract or on her instance. In those cases, she has the one who has created the situations, who is somebody who has created the situation, contributed that. So then in that case, being a contributor to the situation, she cannot again be considered a victim of the situation. Subsection 5 says, on proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate can cancel the order. So it's not that once the order is made and later these things come in picture, the order can be cancelled. So which is the grounds of maintenance order, which is the subject of section 144. It is for wives who are unable to maintain themselves, and uh, children who are legitimate, illegitimate, but whether married or not, who cannot support themselves, adult children with disabilities, and parents. These are the people under scope. Order for monthly allowances can be given by the court, and the amount of the allowance will be determined by the magistrate based on what they consider appropriate for the maintenance of the wife, child, father, mother, whoever in question, or sometimes there is a lump sum settlement also, which happens in those cases. Provision for the female children is an exception again given where if the female child who is minor and her husband is also minor, and until they reach the age of majority, if they are not earning anything, so this is an exception which is taken because in subclause C of 1 it says a married daughter is excluded, but our married daughter is when not excluded when she has not attained a majority and her husband has no means of or sufficient means of income. Interim maintenance order is also discussed in this section, which talks about an interim relief has to be given. The legal principle says, as per the Supreme Court judgments, also that any interim order has to be definitely considered to ensure the wife and the children or the parent in that sake are living into the life standard where there is no damage to their life happen, which is irreversible. So to avoid any irreversible damage, the interim maintenance has to start immediately from the date of order or from the date of application itself, because they were the parties who were in need of that money from that point of time, to so avoid any such irreversible damage to the families who are depending on that person. This particular interim relief has to be immediately given. And that is why it says a timely decision for interim relief also has to happen within 60 days of serving notice to the other party. And the effect of the order is that basically from the day of order, or it may be from the day of the application, discretion to the court, but both the options are given. And the consequence of non-compliance, if the person fails to make the payment as ordered, the magistrate can issue warrant to recover for recovery through the same means used for collecting fine, or this could lead to imprisonment for non-payment extending up to 1 month also, ensuring an enforcement of the order. There is a limitation of the provision also given, that if a wife is living in adultery or refuses to live with her husband without sufficient justification, etc., and they're living separately by mutual consent, etc., she is not entitled. And cancellation of the order also happens if even after order it comes to the notice of the court that yes, this is a case of either of these options, then the court might go ahead and cancel the maintenance order. So this is a legal protections for the dependents, close dependents, which is given under this section. It gives an efficient legal process to ensure their lives are not uh, hanging in air, and there is a check and balance given for ensuring it is not becoming an extortion to the other party also, which is a very common situation nowadays. Section 145 is the procedure. So proceeding under section 144 may be taken against any person in any district where he is, or where he or his wife resides, where he last resided with his wife, or as the case may be with the mother or the illegitimate child, or where his father or mother resides. So in either of these jurisdiction, this matter can be taken. So if a person stays in Pune and the dependents live in some other city, it can be taken in Pune. Where he and his family both are residing in Pune, it can be taken in Pune also. Where he has resided last with his wife, and the wife has now gone to the matrimonial house, or the case may be with the mother or illegitimate child, then also in that city that can be instituted. And where his father or mother reside, there also it can be instituted. Because they are senior citizen, the benefit is given to him. Or under subclause B, where the wife resides, she can also file there, because she is at the place where she has taken the shelter. So shelter is regarded in the eyes of law where the lady who has no means has taken a shelter to support her life. So that city is also a jurisdiction. Subsection 2 says all evidence in such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with in the presence of his advocate, and shall be recorded in the manner prescribed by the summons case. So it has to be evidenced that way. Provided that if the magistrate is satisfied that the person against whom an order for the payment of maintenance is proposed to be made is willfully avoiding service or willfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte also in this matter. And any order so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms as to payment of cost to the opposite party, as the magistrate may think just and proper. The court is dealing with application under section 144 shall have power to make such order as to cost as may be just. So maybe what is appropriate. So this is a venue of the proceeding, what it could be, which jurisdiction of the court. So about this venue of the proceeding, this particular section talks about. So this is the individual against whom proceeding are brought, wife, etc., what we have just mentioned. Evidence gathering, it mandates that the evidences must be taken in the presence of the individual against whom maintenance is sought, or in presence of the legal representative, the advocate who is standing for him. And all the parties have a chance to directly participate in the proceeding and respond to the evidence being presented. Um, the evidence should be recorded as per the summons case procedure. And why summons case procedure? Because these matters have to be closed as soon as possible. The ex parte proceeding can happen if the person seemingly is not attending, neglecting willfully, or avoiding without any notification and permission to the court. In that case, court is free to take an ex parte proceeding and set aside also any individual, any other previous order, etc., if it is required. And it has an authority over the cost where it can put a cost accordingly. Now we move to chapter 5, 8. So chapter 8 is procedure, alteration, and enforcement, which is continuation of the sections in the chapter of BNSS. So let's move there to section 146 and 147 after that. So we in the previous one we saw it could be waived also at later point of time. Alteration in allowance. So on proof of a change in the circumstances of any person receiving under section 144 a monthly allowance for the maintenance or interim maintenance, or ordered under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father, mother, as the case may be, the magistrate may take such alteration as he thinks fit in the allowance for the maintenance of the interim maintenance, as the case may be. So if any proof is given that there is a change in circumstances of the person receiving, so then in that case, the alteration can happen. So for example, the child was studying in a school and then he moves to an engineering college. That change of the circumstances has come and there is the requirement of the monthly maintenance goes up because now he has to pay an engineering college fee, or maybe vice versa also. The child has started to earn, has crossed his engineering examination. He does not need a maintenance anymore. His share of maintenance has to be removed. So any addition, subtraction, whatever happened is part of the alteration. It could be positive, negative, either way. Subsection 2 says, where it appears to the magistrate that in consequence of any decision of competent civil court, any order made under section 144 should be cancelled or varied, he shall cancel the order, or as the case may be, vary the same accordingly. So in case of any consequence of a decision of a competent civil court, the section for 144 order could be cancelled. As I said at the start, these sections have both a civil and a criminal flavor. So that is why this is impacted even by a civil court order. Subsection 3 says, where any order has been made under 144 in favor of a woman who has been divorced or has obtained a divorce from her husband, the magistrate shall, if he is satisfied that a woman has after the date of such divorce remarried, then cancel the order because she does not need the maintenance anymore from the date of her remarriage. The woman has been divorced by her husband and she has received, whether before or after the date of the said order, the whole of the sum, which under any customary or personal law applicable to the parties was payable on such divorce, cancel such order in the case where such sum was paid before such order from the date on which such order was made, and in any other case from the date of expiry of the period, if any, for which the maintenance has been actually paid by husband to the woman. And the woman has obtained a divorce from husband, that she had voluntarily surrendered her rights to maintenance or interim maintenance, as the case may be, after her divorce, cancel the order from the date thereof. And at the time of making any decree for the recovery of any maintenance or dowry by any person to whom a monthly allowance for the maintenance and interim maintenance or any other of them has been ordered to be paid under section 144, the civil court shall take into account the sum which has been paid to or recovered by such person as monthly allowance for the maintenance and interim maintenance, or any of them as the case may be, in pursuance of the said order. So basically this talks about the alteration of the allowance which is established by the orders previously. The cancellation or variation can also happen due to a civil court order indicating that the order should be rescinded or varied. So if any such order comes from, then the magistrate has to make those changes or cancel the order. Conditions for cancellation of order is given, where the first condition is 3A, which says the divorcee woman has remarried. Or in case of some customary, for example, in case of Muslim woman, if the meher is received, the woman has received the agreed upon meher or the dower amount, the maintenance order is cancelled, because then it is customary from that Muslim religion perspective, then there is nothing more required. And if the sum was paid before the order is cancelled from the date it was made, because the settlement has happened already when the order was made and before that time. So that means it is not required at all. So that is why it is then cancelled. And if the sum was paid after the order, it is cancelled from the expiration of the period for which the maintenance was actually paid. So it is then for that period of time, then it is cancelled. Then the other option is voluntary surrender of the right, which is given in the subclause C, which says if the somebody voluntarily relinquishes the right to maintenance after divorce, the magistrate can cancel the order from that date. So if somebody has put a maintenance application in the court while somebody is also running a divorce case, while divorce case judgment is happening, the person relinquishes the right to maintenance after divorce. The person says, after divorce, I don't want anything from my husband. When that sort of order is received, then the magistrate will also cancel this order also to make it in sync. And consideration of a paid amount in civil court decree, it is said that the when a civil court makes a decree for recovery of maintenance or dowry, any kind of thing, it is required to consider that any amount that have been already been paid or recovered by the individual as maintenance under section 124, this ensures that there is no double recovery of maintenance payment, promotes equity in financial obligation. So it cannot happen twice. Somebody might have asked for a interim maintenance in the domestic violence also. They might have also put a 125, which is changed to 144 now, and then somebody might have also put an application in the family court. So all three cannot exercise, although it's not illegal to ask in all the three courts, but utilizing all three is wrong. So in that case, the person has to decide which order they want to utilize for the maintenance. And in this case, if it is already payment has been made, then a double recovery cannot happen. So practical implication basically is a flexibility gives in the maintenance arrangement, and coordination with the civil court is also signified in this, and protection against the abuse of maintenance claim is also which is signified, and transparency in the financial obligation where no double recovery can happen, which is part of this section. So this is something which is protecting right for both the parties. Now, when the order is made, the enforcement of the order of maintenance. So, how it happens? A copy of the order of maintenance or interim maintenance and expenses of proceeding, etc., as the case may be, shall be given without payment to the person in whose favor it is made. So, the wife or the child or the parent or to his guardian, if any, or to the person to whom the allowance for the maintenance or the allowance for the interim maintenance expenses for proceeding, as the case may be, is to be paid. So, in case of child, it might be some guardian also. And such order may be enforced by any magistrate in any place where the person against whom it is made may be, on such magistrate being satisfied as to the identity of the parties and the non-payment of the allowance, or as the case may be, expenses due. So this is a issuance of an order copy which happens under section 147. Enforcement mechanism is then further talked about, that once it is handed over to the person or to the minor's to the person who is taking care of the minor, and the money in whose account it will go. So then enforcement mechanism is given, which says the authority of a magistrate to enforce the order wherever the individual against whom the order is made may be located. So in that area, any magistrate can enforce that. This broadens basically the enforcement reach, allowing for the claims to be persuaded across different jurisdictions. So it is not only have to come back to the same jurisdiction, it can be operated by the magistrate in the same jurisdiction where the person who is supposed to pay is staying. It provides a flexibility and ensures that the legal support is accessible from any location, and it is automatically operated in the area where the person stays. And while executing, it is a mandate for the magistrate to verify the identity of the party, so that wherever the allowances is not paid, the right person is making the payment. So it is a right to access a maintenance order which is brought forward by this section. It is an effective enforcement of across the jurisdiction which is given, and then regardless of any geographical limitation, and accountability of non-payment stays right next to the person's magistrate's door where he is liable to pay the things. Now we move to module 5, the concept of fair trial, presumption of innocence, the right of silence, and right to speedy trial. So this is the first chapter. So let's talk about first the concept of fair trial. So what is the concept of fair trial? So this is a fundamental principle in the judicial system, and which is very crucial for ensuring that the justice and maintaining public confidence in the legal proceeding is established. Because here are basically it can happen that somebody can abuse also by making somebody accuse. So then there should be definitely a transparency, a fair trial, a presumption of innocence until proved guilty, and wherever the person is not incriminating himself or herself, they have a right to silence also, and they have to have a right to have a trial in an open court for transparency, and a speedy trial also, wherever possible, has to be given. Until and unless those fundamental principles are not catered and brought forward, it cannot give a concept of a fair trial to the person, because the trial is from both the sides. When the trial happens, the accused also has a right to challenge it. It has to be given the full right to challenge it, right? The way, very same way, the petitioner or the victim or the applicant has also right to go ahead and challenge him. So it is open for both the parties, one party to challenge anybody, other party to challenge what he has been challenged for. So until this is not given fully to the both the sides, it cannot be a fair trial. So the very important thing is there are certain concepts which are connected to the concept of fair trial. Is first of all the presumption of innocence, which is given a very golden rule in the matter of the criminal trial. So every person who is accused of a crime is presumed innocent until proven guilty. This is something which is very, very important. And this principle protect the individual from any unjust treatment. Because if the law would have said the person who is alleged is somebody who is guilty, then the treatment in the eyes of law, the treatment with the police department, the treatment with the society, everything would have been in a very adverse situation for him. But then this particular principle protects the individual from any unjust treatment and ensure that the burden of proof rests with the prosecution. If you have alleged, you have to prove it. Although there are some special cases which are also brought forward for some heinous kind of crimes where presumption of innocence is not taken. For example, POXO, wherever a sexual offense against a child happens, and if the person is accused of that, the person is not accused of that. The person is considered guilty of that particular crime, and the person has to now, the burden of the proof is on the shoulder of the person who is called accused in this matter. So there are some special cases, but in general, the legal principle, the jurisprudence work on the presumption of innocence, which is the first thing which is helping the concept of the fair trial. Second thing is right to a public hearing. So all the trials should generally be conducted in a public setup to ensure that the transparency and accountability is there. If there would have been a situation where inside a palace, inside a hall, under the four wall, without the scrutiny of public in general, if anything would have been happening, it could happen, and anything, any way can happen. Somebody could have been, and the way the Britishers used to do with us also. So there was no fair trial, and there was no transparency and accountability, and the courts could have violated any law, any principle also in that regard. So that is why a right in a public hearing is also something very, very important. This openness helps the prevent any arbitrary justice and allows the community also to keep a check or witness the administration of the justice. So in general, everybody is watching that. Third thing, which is very important for the concept of fair trial, is the right to impartial judgment. So very essential component of this fair trial is that the trial is having case heard by a independent and impartial judges or the tribunal. So in this, judges, etc., must be unbiased and decide based on the evidence presented. So judges being unbiased is guaranteed by the way we have the setup, and they have to follow the evidentiary route, they have to follow the right procedure, etc., which is all given in the BNSS, etc. And that is something which has to be followed, and that neutrality is guaranteed by the current judicial system. Then, right to a legal representation, which is also very closely a part of the concept of the fair trial, where the accused, the person who is accused, have the right to a legal counsel. If they cannot afford one, there is a government deal, this legal aid, etc., is also provided to the person. Then other point which is guaranteeing the concept of fair trial is the right to be informed of the charges. So the very first point where the trial starts is at the point where the person is informed of the charges, whether the when the warrant is issued, when the complaint is instituted against him and he is arrested, or when he comes to the court also and when the charges are framed. So the defendant must be informed promptly in detail about what are the nature and cause of the charges against him, and so that he can prepare a effective defense. So prepare an effective defense, the person should know what exactly he's been incriminated against. Then other important attribute of concept of fair trial is right to present a defense. So the person has to be given an opportunity to present their case, including ability to call their witness and submit evidences, as the other party can also do. So they can also bring in those evidences and witnesses. Then other attribute is right to cross-examine the witness. So in a fair trial, the defense to question and challenge the prosecution witness is also an opportunity of fair trial, so that they are able to bring in the validity of those witnesses, if they are actually valid witnesses or not. So this process help the any in accuracy and reliability of the testimony of such witnesses. Then trial without an undue delay is also something which is a part of a fair trial. So accused or individuals who are accused should be tried within a reasonable time to avoid prolonged detention and uncertainty. That is something which is a big problem currently, where the people are languishing in the jail, 80-90% people who are awaiting the trial to complete. And even if after some time they are considered not guilty, they might have put a considerable time behind the bars already. So that is the trial without undue delay is something which is very, very important part of the concept of fair trial. Yes, I was put as an accused. Okay, I was in somebody alleged about me. Absolutely okay, everybody has a right to do so. I've been tried for this. I've been considered a risk. I've been put behind the bars. But after 10 years, if the trial finishes and I'm told that yes, you were not guilty at that point of time, I've been already gone through a 10 year of imprisonment without being imprisoned. So that is why a justice delayed is a justice denied. So trial without an undue delay is something very, very important. Right to appeal. So if any order which comes against the person, and for that, against that impugn order, there is an opportunity to appeal for by that person. So this right to appeal is also something which acts as a check against judicial errors or judicial misconducts also. So judicial slippages, etc., whatever happen. Then the final point on the fair trial is the protection against the self-incrimination. So anything which is incriminating self, that the person can rescind. So that's something which is uh, under any kind of force, duress, etc., is prohibited, and that is something which is very, very important. So the Indian Constitution, under the Article 14, 20, 21, and 22, provide lot of guarantees to the people. For example, 14 talks about the equality before the law and equal protection of the law. which forms the foundation for the impartiality in the trial. But then Article 14 also talks about any such kind of comparisons, which are reasonable comparisons, distinctions made between the parties, then that can be considered. It's not something which is ultimate right, but Article 14 fairly covers the equal protection of the law. 21 talks about the protection from retrospective criminal legislation, where the person cannot be retrospectively uh, tried or punished for something which when the law was not even existing when the incident happened. 22 talks about the protection against double jeopardy. Being tried for the same offense more than once cannot happen. 23 talks about the protection against self-incrimination. While 21 guarantees the right to life and personal liberty and interpreted to include the right to fair trial and avoid any kind of illegal, unfair detention. 22, which provides a specific right related to arrest and detention, includes the right of informed of charges and the right of legal representation. While if we see the BNSS, the section 47 and 48, which is giving rights of the arrested person to be informed of the grounds of arrest and right to bail, which is reflected through section 47 and 48. Section 314 BNSS, it talks about right of the accused to be defended by a pleader of their choice, reinforcing their right of legal representation. Section 341 talks about the free legal aid, etc., to the accused who cannot afford such representation that has to be provided. And Section 346 talks about that ensuring that the trials are conducted without undue delay. If there is a delay, it can be challenged and there should be a reason. The prosecution, just because they have brought the case on the in the court on the board, they cannot do a delay unreasonably, and that is something the right given them to challenge that also. So that is something which is helping in the fair trial. Section 351 BNSS talks about providing the accused the right to explain the evidence against them during examination. So the person has to be explained things, and that is giving a chance for him to receive a fair trial, but without making a confusing or difficult mistake. Section 366 talks about ensuring that the courts normally conduct trials in an open court and reinforcing a transparency, which is given by BNSS procedure. And Section 354 talks about it is something which is dealing with the questioning of the witness or by defense, supporting the right of the cross-examination. So they can also do a cross-examination of the witness of the prosecution. So these constitutional articles and the provisions in the BNSS comes in the picture to ensure that whatever the key points of the uh, a fair trial should happen are taken care. For example, presumption of the innocence, right to the public hearing, right to the impartial judges in the tribunal, right to the legal representation, right to be informed of charges, right to be present defense, right to cross-examine the witness, trial without an undue delay, and right to appeal and protection against self-incrimination. So all these things together gives a concept of the fair trial where the rights of the accused also are very well protected to ensure that a fair trial happens. Because from the side of the prosecution, it is always an opportunity which is given and they always get an upper hand, but it does not mean the accused will not get any opportunity fairly equal to defend the same. If you see, even in the cases of the executive magistrates also, in the case when there are orders, etc., passed for the public tranquility, nuisance, etc., then also the orders, before becoming absolute, they have to be verified together with the parties involved and given an opportunity to them, in, even up to the level where they might reach out to some competent court to bring in the required judgments to help that kind of order to stay or vacated. Second point of discussion is in this chapter 1 is presumption of innocence. So let's talk about presumption of innocence in a little bit more detail. So the presumption of innocence, which is a fundamental legal right, that legal principle, sorry, that dictates that any person accused of a crime is considered innocent until proven guilty. And this is something which helps which is a very important cornerstone of the criminal justice system around the world, which ensures a fair treatment for defendant throughout the legal proceeding. Otherwise, there is no locus standi for them to stand and defend themselves. If they are considered guilty in day one, then where is the locus standi to come back and stand and defend themselves? If you are a guilty day one, you are a guilty day one. Then only thing which is remaining is the punishment to be pronounced. So the key component of the presumption of the innocence, what are the key component of this particular concept is equality of the treatment. By this, what we achieve is an equality of the treatment. Whatever the criminal proceeding is happening, it is essential that the accused and the prosecution both are treated equally. And for that, the balance is crucial in enabling a fair trial and upholding an integrity of the judgment judicial process, that negligence in treating the accused unjustly or without bias, with bias, can definitely lead to miscarriage of the justice. And for that sake, to avoid the miscarriage of the justice, both have to be treated on equity, because equity is the basic fair principle of the law. And equality treatment, the equity is something which is one which drives the one of the component which drives the concept of the presumption of the innocence. What is the second point which is important about the presumption of innocence, which establishes the principles presumption of innocence, is the right to be treated as innocent. Everybody has a right to be treated as innocent. The accused has a unequivocal right to be presumed innocent until their guilt is established, because he is not somebody who is incriminating himself. There might be other purposes, very well thought of purposes, which might be conspiracies against them also, which might be putting them as an accused in front of the court of law. So that is why the person has a right to be treated as innocent also until the guilt is established, until a beyond a reasonable doubt. So the in the legal principles of the crime, the criminal law, it's always the phrase which is used is beyond a reasonable doubt. So beyond a reasonable doubt, the person has to be proved guilty to be, otherwise the person has a all right to be considered or treated as innocent. This is a notion which is something securing the right of the individual and reaffirm that the burden of proof lies with the prosecution, not with the person. So in the defense, normally how it works, the matters in the court is primarily why failing all the allegations or witnesses, if that is also done, and even if not, additionally any proof is brought about the innocence of the person, then also the cases are won, because all the evidences and the witnesses, if fails of the prosecution or majority of them also fail, in that case the reasonable doubt or the reasonability of the prosecution is not proved. No need to even sometime prove the person is innocent. If the allegation is also neutralized, then also the person is not proved beyond the reasonable doubt as into his guilt. So, right to be treated as innocent is another very important component apart from equality of treatment for the presumption of innocence. And what is the other one is burden of proof is a very important concept which comes in picture when presumption of innocence is talked about. And this is something, the fact of the case lies explicitly with the party asserting them. So the party which is asserting, it is with them. So in section 104 and 105 of the New Evidence Act, which is the BSA, Bharatiya Sakshya Adhiniyam, the prosecution must establish its case against the accused. And it is crucial to understand that the presumption does not shift the burden, but begins with the prosecution. So that is how it is taken by the BSA also. So importance of this presumption of innocence is it protects the against wrongful conviction. Had this not been there, the wrongful convictions is easy to happen. So the presumption of innocence is a very vital part in the defense also. If a defense lawyer goes with a mind or mindset of a fair trial, it will not be very much valid, because fair trial, yes, it is very, very important for defense, for the defense perspective, but it's a very wide concept. While the presumption of innocence is a core concept which helps in the defense. It's a very core concept under which every defense lawyer operates. So they have to safeguard the individual from wrongful conviction through this and any unjust outcome, and it ensures that the legal process is not misused and individuals are not punished based on assumptions or inadequate evidence or false evidences or false allegations from the prosecution. Even if that is safeguarded, if that is also neutralized, then also the case is won. What is the second importance of what we achieve from the presumption of innocence is right to a fair trial. So fair trial is also one of the component was the principle of innocence. So this principle is intertwined with the concept of fair trial. It is one of the component which is driving the fair trial. So this is one of the engines which are driving the fair trial concept, and it is a fundamental human right to get a fair trial, which is driven by the presumption of innocence from inside. So it obliges that the prosecution has to prove all elements of alleged crime, etc., in the judicial process, not the defense. And it helps in the prevention of the miscarriage of the justice, also the prevention of the presumption of innocence. And again, this is a fundamental right also, which is enshrined in the Constitution of India, particularly Article 14, which talks about the equality before the law. If you are considered somebody who is a victim and who are coming back complaining to the court, I do have an equal right to come back and say I am not the one who is guilty. It is might be somebody else, but I am not. I can also plead before the court not guilty. So that is the equality before the law of both the parties coming back. And if the prosecution has a right to go back in front of the court and plead any help from the court, any justice from the court, I do have the right to plead the justice from the court, saying I am not guilty. Article 21 also gives a protection of life and personal liberty, which is achieved by this one. So, as a fundamental right, this cannot be also overlooked. And a principle guiding state of power. When we talk about the principle guiding the principles of the presumptions of the innocence, which is a guiding framework for the state also when exercising its coercive powers, the powers, ensuring that the state acts within the responsibility and integrity. So, in all the situations what we have studied today also and before that also, we've seen that the state also when operates, they have to understand and presume that the the smallest of the mistakes have been made and the lowest of the power has to be used. And that is why the presumption, if that would not have been the case, if there would have been a gathering which would have been coming and the state would have considered these are terrorists, come and shoot them, then they would have taken the highermost order of action. But they have to also presume the innocence that the people are coming there, maybe for some reason they are even allowed to do that. But then to safeguard the public tranquility, have to use the minimum power. So in all those areas, also not only the court, this presumption of innocence also helps in investigation, trial, charge, and any such scenarios of administration as well. So there are notable some cases which are very, very important in this direction, which is Kaliram versus State of Himachal Pradesh, 1973. In this, where the in this landmark judgment, the case established that the individual cannot be held guilty unless proven beyond a reasonable doubt. And the Supreme Court highlighted that the prosecution must effectively rebut the defenses presented by the accused with credible evidences. It cannot be just superficially rebutted. It has to be very strongly and very reasonably, credibly rebutted. There should be credible evidence around that. And the case was significant in affirming that the right of the accused and standard required for a conviction. What standards are required? This is drawn in this particular case called Kaliram versus State of Himachal Pradesh, 1973. Then Nanavati case, which is KM Nanavati versus State of Maharashtra, very famous case where we have the Akshay Kumar movie 1962. In this case, also the Supreme Court reiterated that the presumption of innocence is a general principle in the criminal justice system, and the burden of proof lies with the prosecution, reinforcing the requirement for the prosecution to establish the guilt of the accused unequivocally. And that is why Supreme Court, as I mentioned multiple times earlier, also continuously is saying, first of all, the bail is a rule, jail is an exception, and that is nothing but the based on the presumption of the innocence. Let's talk about the right of silence little bit in detail. So the right of silence is also a fundamental principle of law, common law system across the world that protect the individual from self-incrimination. If I don't want to speak, I have my fundamental principally, I am allowed to do that. And it is something which an individual should not be compelled to answer questions or provide evidence that will incriminate them in the criminal proceeding. So this principle holds a great significance basically in ensuring the fair and just legal process happens of the judiciary and finds its place in Article 23, as I said at the start. And it will explore the let's see how it has been established. The right to silence, how it has been established over time in the judicial system. So it has roots in medieval England. The medieval England that has got the roots of this kind of philosophy. So notable development occurred during the 16th century in the English courts act of Star Chamber and the High Commission courts. So they compelled the suspect. There was a term called ex officio oath. So they compelled the suspects to take an ex officio oath and answer questions even without formal charge. So refusal to take the oath could result in torture. Then they were tortured at that point of time. So, the right of silence, which is grounded in the principle nemo debt prodere ipsum. Nemo debet prodere ipsum, which means no one should be compelled to accuse himself. So this privilege against self-incrimination eventually becomes one of the cornerstones of the legal protection. So what are the key facts around the right of silence is the very first thing. Several essential facets are there to protect the accused in terms of the right of silence. One is the burden of proof. The criminal proceeding, the burden of providing the accused's guilt rests squarely on the state or the prosecution, both together either. And this means that the prosecution must establish the accused's guilt beyond a responsible doubt. That is their responsibility. And that is always on the shoulders of them. So in case if I have to respond somebody as somebody who is accused, it is something where the Supreme Court has also said, reaffirm that the burden of proof is on the criminal case is always on the prosecution. So if I need not respond something, it is fine. And this is very well given in the case of State of Bihar versus Basavan Singh of 1958. Then there is an interconnectivity again with presumption of innocence. So until proven guilty, any accused is presumed to be innocent. And this presumption is also something which is safeguarding the accused from undue prejudice and undue pressure to speak. And this is also proved by the judgment of Anant Chintaman Lagu versus State of Bombay, 1960, where the Supreme Court says the importance of the presumption of innocence is important, and that is why the right of silence is also, which is associated, is naturally going to the accused. Protection against the self-incrimination, which is in Nandini Satpathy versus P.L. Dani, 1978, where the Supreme Court upheld that the accused's right to remain silent is to prevent self-incrimination. The right of silence is something which is given to the accused as a privilege to remain silent and not being compelled to incriminate himself. And accused cannot be forced to answer questions that might implicate them in a crime. So you have to be tricky when you ask such questions. If they feel there is incrimination, they can choose not to speak. So there are some exceptions also to this. So the right to silence, there are some exceptions. There are exceptions, for example, in certain circumstances, the law may compel an accused to submit to investigation. Such photographs, such voice recordings, such biological materials, blood samples, DNA. So those things also speak against that particular accused, and that is also covered as an exception to the silence of right to silence. So right to silence is not only talking about the verbal silence; it is any statement made by any of the evidence also which is speaking against the person. And these exceptions could be the kind of statements they have to ask to made. They are gone through some kind of special medical examinations where they are put under drugs to go ahead and speak. But then this is not considered directly as an evidence, but then it is part of the investigation which it is allowed. Sometimes some photographs, videographs, and audio recording of that person is also allowed in the court, which is something which is against the right of the silence, but it is an exception which is allowed. And other blood samples, DNA, etc., taking out from the body of the particular accused is also something which is against his right of silence, but then that is something which is allowed as an exception, depending upon the discretion and of the reasons which could be recorded in writing by the court in the fair justice delivery of the justice. Now, international perspective of this right of silence is something also which impacts very much the Indian judiciary as well, where it is something not only confined to India. It is an internationally agreed fundamental human right, and this is part of the UDHR of the Universal Declaration of Human Rights, which was made in 1948, and this is something which is enshrined there also. And the International Covenant on Civil and Political Right, 1966, on which India is party also, where also it safeguarded the self-incrimination. And the burden of proof, which is important to understand between the two types of the burdens in legal proceeding, the legal or persuasive burden of proof, which remains something which is constant and never shifts. So the legal or the persuasive burden of proof, it never shifts. And the evidential burden, where the it can shift during a trial. In modern statutes, basically, the burden of proving a particular claim or charge remains with one party. The evidential burden can be shifted to the opposing party. So it is evidentiary burden of proof which shifts. For instance, in civil case, for example, a plaintiff needs to prove that the defendant owes them some money. Now, due to loan. Now, under Section 118 of the NI Act, Negotiable Instrument Act, if the defendant has executed a negotiable instrument, some kind of negotiable instrument check, etc., in favor of the plaintiff, the initial evidential burden shift to the defendant to explain the situation. So this is because of the evidence which was presented. So this shifting of the evidential burden is also applied in the criminal cases, particularly when the accused is found in possession of property deemed illegal, such as drugs, stolen arm, etc. Then also it shifts. So basically, there are multiple challenges, there are multiple exceptions, but the various the constitution articles, the provisions like Article 23, 20, bracket 3 of the Constitution, etc., provide a testament of protecting the person, uh, their right to silence and their other rights. While BNSS has some sections which are also talking about the same, the right of silence. So, Section 180, section subsection 2 of Section 180, it says the right to silence during police interrogation if stipulates that a person must answer all questions truthfully, except those that might expose them to criminal charge or penalty. This provision strikes a balance between the need of the investigation and the protection of individual right. So this gives a right of silence, section subsection 2 of Section 180. Subsection 3 of Section 351 says, as the trial stage, at the trial stage, this section safeguards that the right of the silence, and the accused is not liable for punishment for refusing to answer questions or providing false answers. So this provision ensures that the accused person cannot be compelled to incriminate themselves during the trial. And section subclause B of subsection 1 of Section 353 of BNSS says, this provision precludes any comment by the parties or the court regarding the accused failure to give evidence. And it reinforces the presumption of innocence and prevents any adverse inference based on the accused's silence. So this is something which is all coming from the Article 20, Clause 3, and which is emphasizing the protection of the right of the person for the fair legal process and his right of being silent. So the very famous Supreme Court cases around right of silence is Nandini Satpathy versus P.L. Dani, which I mentioned earlier, where the Supreme Court has also brought the importance of this particular by the Justice Krishna Iyer. He has emphasizes that the historical significance of this particular right is something which is very, very important. And this is a very important tool also as a response to the atrocities by the police also. So, Nandini Satpathy versus PL Dani, the case the Supreme Court upheld that the principle that an accused has the right to remain silent both before and during the trial. Before and during the trial, particularly if answering questions might expose him to guilt, Justice Krishna Iyer emphasized that the historical significance of this right as a response to torture during investigation. So even during British time, our people used to be remain silent in spite of being tortured very badly. Selvi versus State of Karnataka is another matter where the Supreme Court examined the admissibility of a statement made during the custodial interrogation, and the court held that the statement made to the police during the interrogation are not admissible until and unless they meet the stringent requirement of the voluntaries and the reliability, and so it could be any kind of silence also is admissible and not doesn't goes adverse against the person not making it. State of Maharashtra versus Bharat Changalal Raghani. In this case, reaffirmed the importance of the right of silence during police interrogation. It emphasizes that the accused cannot be compelled to answer questions that might incriminate them. So, this is something which is a very, very important right given by multiple countries, including India. And the last topic for the day is the right to speedy trial, which is also a very, very important right. And it is a fundamental, again, aspect of the justice system for getting a fair trial. The right to speedy trial is very, very important. And this is something which protect the interests of the accused. As we said, justice delayed is justice denied. Importance of the right is prevention of injustice because delays can cause just injustice by themselves. Preservation of evidence also is very, very important because it cannot be considered always for infinite time it will be available. And protection of the rights is also very, very important because it reinforces the presumption of innocence, but maintains a integrity of the judicial process because the person's rights are also safeguarded. So a quick judgment will always help the person who is accused and might not be guilty, and it upholds the trust into the legal system. Constitutional provision 21 and 22 article is something which is connected to this, which is guaranteeing the right to the life and personal liberty, and the Article 22, which provides the right legal to arrest and detention. BNSS sections 346, 487, and 479 are relevant, where Section 346 talks about the when there is a trial is postponed, it should be done with utmost urgency, and the every endeavor should be made to conclude the trial without delay, and specifically state what exactly is the reason why it has been delayed. Section 487 talks about the discharge of the accused if the trial is not concluded within a prescribed period and the accused has to be acquitted. And accused person is not tried within the time specified, they must be discharged from the charges also, and symbolizing the importance of a speedy trial. In case of uh, such a delay, the person will be discharged. Section 479 says this section provides that an under trial prisoner shall be released on bail if they have been detained for more than half of maximum period of imprisonment prescribed for the offense they are charged with, or if first time offender even on the one third consumption of the imprisonment time. The famous landmark judgment around the right to speedy trial is Hussain versus Union of India, 2017, where the Supreme Court reinforced the right to speedy trial, emphasizing that this right is implicated in Article 21, and the court observed that the undue delay in trials lead to erosion of the faith of the masses in the justice delivery system. Khatri versus State of Bihar of 1981 is also a matter where the case highlighted that the need for procedural safeguard to ensure the individual do not suffer due to delays in trials, affirming that the right to speedy trial is an essential part of the right of life. So this is also something very, very important, and that's all about the chapter 1 of module 5, which is concept of fair trial.